Fresh matters you can give. Fresh matters you can give. Fresh matters. Please give it. Please give it, madam. What can be done now? Please give it. I am saying, please, fresh matters you give. You are not ready to give. If you don't give, you please keep it with yourself. Kodri, dayaviಟ್ಟು ಕೊಡಿ, please give. You are only a complainant. You are only a complainant. Petitioner Seriamma, you are a complainant against your neighbor. ಮತ್ತೆ ಏನು ಅಂತ ಅರ್ಜೆನ್ಸಿ ಕೊಡಿ ಪ್ಲೀಸ್. ಹಳೆ ಮ್ಯಾಟ್ರಾ? ಇಲ್ಲ ಇಲ್ಲ, ಇಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಟೇಕನ್. ಎಸ್ ಎಸ್. ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ. ಏನ್ರಿ ನೀವ್ ಹಿಂಗೆಲ್ಲ ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಬರ್ತೀರಾ? ವಿ ವಿಲ್ ಎಲ್ಲ ಹಿಂಗೆ ಹೇಳೋದು. All of you will tell the same thing. You will repeat the same thing. You will see. Circle. ಬರುತ್ತೆ ಕೊಡಿ. IF ಅರ್ಲಿ ಹೆಂಗೆ ಬರುತ್ತೆ. ಎಸ್ Yes. Huh? Serial number 36. Learned counsel for the petitioner has filed a memo dated 28/6/2023 seeking leave of this court to withdraw the petition. Stop. The memo is taken on record subject to all just exceptions. Accordingly, the petition stands dismissed as withdrawn. Yes. Hmm. I learned AGA takes notice for 1 and 2. Issue notice to respond number 3. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA. ಒಂದು ಬಂದಿದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? Please take instructions. Really matter. ನೀವು ಈ ತರ ಬಂದ್ರೆ ವಿತೌಟ್ ಇವನ್ ಕನ್ಸಿಡರಿಂಗ್ ಹೌ ಕ್ಯಾನ್ ಬಿ ಸ್ಟಾಲ್ ಇಟ್ ಸರ್? ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. Really matter on 5th of July. ಆಯ್ತು 4th. ಆಗೋದಿಲ್ಲ. No, let us see. Let him take instructions, sir. He doesn't have any instructions. Yes. No. Huh? 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 ಸರಿ, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು? ಹಾಕಿ. Yes. Statement of objections have been filed at the hands of the 6th respondent KIDB. Stop. Learned counsel for respondent number 7 submits that since serious allegations are made against the 7th respondent in the statement of objections filed by the 6th respondent, the 7th respondent may be permitted to file an affidavit or a rejoinder. Stop. A week's time is granted to do the need. Realistic matter on 7th of July. Yes. ತೊಂದ್ರೆ ಇಲ್ಲ. Even if it doesn't come back, there is no difficulty. No. ಹಂಗೇನು ಆಗೋದಿಲ್ಲ. ನೀವು need not worry. You please come next week. Yes. Gram Panchayat. They issued notice. At annexure D. Learned AGA takes notice for respond number 1. Issue emergent notice to response number 2 to 4. Returnable by 19th of July. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA.
Petitioner matters. Petitioner for seeking for mandamus. My application seeking katha, the subject property is kept pending. I also made representation on 29/11/2022. Same is also kept pending, my lords.
Appeal. Direct the zonal officer. Issue BBMP katha.
Malas, actually, it was learned that Malas, the society from which the site has been crowded out was subject to proceedings under 79B of the Land Reforms Act. This honorable quashed the proceedings. Malas, have produced the copy at annexure H. Now, in view of annexure H, Malas, there are no impediments for the respondent BBM to issue katha.
This information you have not provided to the officer.
Yes, by way of
even in your communication at annexure A.
Yes, my lord.
You have not stated so.
Malas, in another representation, I have.
Which representation?
Just a second. Annexure K, Malas.
ಅದರಲ್ಲೂ ಇಲ್ಲ.
Malas, annexure J blueprint. Annexure J, annexure J, annexure J, Malas. Page 50, Malas. Para 3, Malas. May I read? ಸದರಿ ವಿಶ್ವಭಾರತಿ ಗೃಹ ನಿರ್ಮಾಣ ಸಂಘದವರು ನಿರ್ಮಿಸುವ ತಮ್ಮ 5ನೇ ಹಂತದ ಬಡಾವಣೆ ಸಚ್ಚಿದಾನಂದನ ದ್ವಿಭಾಜಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಮ್ಮ ಬಡಾವಣೆಯ ನಿವೇಶನ ಮಾಲೀಕರು 2012-14-17 ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ದಾವೆಯನ್ನು ಸಲ್ಲಿಸಿ ಸದರಿ ದಾವೆದಾರರ ಪರವಾಗಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು 33/2001 ತೀರ್ಪನ್ನು ಆಗಿರುತ್ತದೆ. I have produced the copy of this judgment also.
Learned AGA takes notice for respond number 1. Learned counsel Shri Pawan Kumar, who is present in the court, takes notice for response number 2 to 5. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for the respondent BBMP and a copy on the learned AGA.
Okay.
Release this matter on 5th of July. Please take instruction.
Okay.
But into yes.
Petitioner predecessor was vested with title, the virtue of the Katha, issued by the Court Development Office, Revenue Office of the Government of Karnataka. Pursuant to that, it was within the limits of the Panchayat Road. Katha was entered in the record of the Panchayat. All those documents have been produced. After the property came to the jurisdiction of DPA, an application was made to have the Katha registered in the record of the DPA. There was apparently an inaction of the power of BPMP responding to the application. As a consequence of it, the retention gets required for court.
Hmm.
And this court has directed the corporation process the application and consider the same on merit within a period of 2 months.
Hmm.
Or that order. Page number 3, page 41.
Hmm. Yes.
No response for within the 2-month period. But after 2 years, they would respond. What is the next step?
Hmm.
Stating that they have written to the deputy commissioner for a confirmation and a no objection certificate for us to proceed further in the matter of transfer of power.
Hmm.
And that is followed by another communication at page number 45.
Not 2 years. Writ petition was disposed of in June 2012. An endorsement was issued on 8th of August.
Basically, the corporation work correctly. They would be, but the reasons there was no communication to me as to why they would suspect my there was no communication with me. The direct communication with the we have kept it dark.
Yes.
Of these issues.
And
eventually on 4th September 2026, they issue an endorsement. 4th September 2014. Stating that there is a rival claim by one Mahila Mandali. Can you see paragraph 3 of the endorsement?
Yes.
Produced Patra or extent of 235 and 40 feet, which covers about the size of the oil patent. For the very first time, we were informed about this.
Yes.
And then in this endorsement, the corporation says you have to resolve this issue because there is a conflicting title issue between private parties on the same property. Resolve this issue and come back to us and then we transfer the car. After that, the petitioner had moved the deputy commissioner for a confirmation about his rights.
Yes.
The deputy commissioner writes to the Panchayat office, the erstwhile Panchayat office, a lot of mine at page number 49.
Hmm.
And after that, there is no response. That is the communication dated 25th March 2015. And after that, there is absolutely no response whatsoever. And about then, petitioner again, Annexure L, writes to the corporation, calling upon them to have the katha restored in his name. And my lord, for the very first time, an endorsement is issued that this land has been kindly see into the one of the challenge at page 51.
Yes.
They say that the DC has reserved this land for Dr. Ambedkar Bhavan, and therefore we are not in a position to. We are absolutely no principles of agriculture. It is true, and we have no rights, and we are purchasers. We need to notice as to why our rights are being denied. And then my lord, kindly see construction starts on the 5th of June by the corporation, not by the other rival claims.
Corporation, the Ambedkar Bhavan.
Rival issue. Don't have it outside its mind or come to a conclusive decision. They would take contradict first the Mahila Mandali, and then in Annexure M, they would say it's Dr. Ambedkar Bhavan. And we have no clarity on title. Another, honestly speaking, if my title is in the cloud, I have no rights, then I'm out of it. But I have invested money, 5 of us, petitioners, of the property. We are.
But see, the prayer in your writ petition is to quash the endorsement and direct them to transfer the katha in your name. In this situation, it is not possible to direct them.
If there is a dispute, I'm not getting cloud on my title, which I'm still not, I'm hard to understand.
Correct.
I presume there is some issue.
Yes.
I have not been informed of proper opportunity has been given
Correct.
to address. Even to find out that there is a cloud on my title, some basic information will come to me. And if there is a cloud on title, then I will take legal advice whether I should go to court and get a declaration of title or not. Even that first step is not made. And the corporation issue is there is a dispute.
But your interim prayer to restrain them will be in a nature of temporary injunction, which cannot be granted here. We are only concerned with the powers of the corporation to transfer the katha in your favor. That is the main question here. In that guise, if you are asking for an interim order to restrain them not to proceed with construction, it will be beyond the powers of the court. You have to approach the civil court.
We have approached civil court. We have opposed civil court. May I make-
Then you will have to get an order of temporary injunction.
We have opposed civil court against the rival claims. The corporation has taken a stand here that we resolve the issue of very right here. Statutory body can't favor anybody. Statutory body is right. Wisdom has said you resolve the title issue, come forward. That is the case, and suit of any island properly suit numbers. But in the meantime, that is a rival dispute over title. Corporation was taking title. The rival dispute between private parties. Corporation, having said that there is an issue on basis of material it was kept dark from me, they arrived at a decision without informing me. Fair enough. That principle of matter that have been violated. Even for that decision, I could have been given a so-called notice.
Correct.
No opportunity of giving you.
Yes.
Having said that, having admitted there is a rival issue. Now the corporation then says, yes, at least suit be decided. Until then, we hold our. That extent, my law will protect people under the matter because they are not party to the suit. The private litigants are party to the suit. Otherwise, my law.
We are only concerned with the question of transfer of katha.
I understand my law. What I would submit to you for this, until the matter is decided, the katha issue cannot be decided in one favor or the other's favor. It all depends on how the matter is resolved finally. Until then, should not the corporation wait for the outcome of the dispute?
So we can say something only regarding the katha
Yes.
and dispose of the writ.
Yes, my lord.
As and when you succeed in the suit,
Yes.
you will be entitled to have your name entered in the katha.
Yes, absolutely. My lord is very right that we I completely borrow the quote on that. But my lord is right. This is between private parties where disputed document possibly they might have a both documents on the same property will be the subject matter of adjudication by civil court.
Correct.
The corporation will then act on the outcome of that case.
Correct.
Corporation cannot be judged.
Correct.
And the proceeding, the construction is being done on favor of one of the private parties before the conclusion of the adjudication. So much of protection for the statutory body and satisfied. I will determine my right without the rival party in the civil court. Corporation going to request the corporation's change of katha either for me or for the rival party would depend upon the outcome of the case. To that extent, my lord may make the observation. The construction is not by the private party. Construction is by the corporation, which means they have admitted or decided in their mind that the rival party is the rightful owner, which they cannot do because the matter is
No.
litigation.
Corporation is doing it. It is doing it for the deputy commissioner who has reserved the property for construction of Ambedkar Bhavan.
But that is the case. I
Yes.
have not been thinking of basic.
Therefore,
principle of justice.
all these questions,
On the basis, I'm not on the point of any other.
I will only make observation regarding the katha and dispose of.
DC order is not been communicated to me. Can you see the order? Can you see the?
Correct, sir. You may have a very good case. But if you are asking for an order of injunction, you name it as a direction. Yes.
My lord, may I make it?
Yes.
Hypothetically, my lord, I could say, there is a matter, and I am entitled to prima facie title, you know, my father was predecessor corporation municipality.
Yes.
And therefore, under the Provincial Corporation Act, I am entitled prima facie for a transfer of katha in my name. If anybody wants to change of katha, it's for him to go to court and establish his right. To that extent, my lord, I agree with me. Now, the rival claimant has not produced anything at all. A reference is made after many years to a DC order, no date of the DC order, no reference number, no copy of the DC order. So then, how am I to accept that there was a DC order? And even if there is a DC order, principles of natural justice, should I not be informed and put to notice that DC was passed to order because of E reason? Therefore, my lord, the enforcement is lax.
Your submission could have been accepted had your name been entered in the register of the BBMP. And without asking you, they had removed it and inserted some other name. But that is not the situation. You made an application asking for entering your name in the katha register. The problem started there. Till now, your name has not been entered in the register of the BBMP.
Nobody's name was entered.
Correct.
Nobody's name was entered.
So therefore, we will simply say that as and when you succeed in the suit, you are entitled to have your name entered in the katha register.
By default, there was presumption that the other side is attacked.
Yeah.
By default.
I am not going to say anything about the registration of the katha in in favor of someone else.
There is no
That is not the issue here.
No, the other corporation.
Your only contention is that you have become the owner of the property under a registered document. And in terms of the provisions of the act, you are entitled to have your name entered in the land records. In
If I may just supplement,
Yes.
my lord, if I'm not entitled, I'm entitled to reasonable notice of reason why I'm not entitled. A statutory authority has to act fairly. It is entitled to deny me the right. Should it not inform me why? Now it reverts to a DC order after 5 years after a writ decided by the court.
Fine.
And DC order. I want to my lord clear this. I think I said everything I can. What I'm thinking is that irrespective of my private dispute, I will get.
you have not brought any document before this court showing that the katha has been entered in the name of some other person. In spite of your application,
There is a communication with the corporation saying.
you have not.
Communication with the corporation
If you
saying.
had brought any such document,
Yes.
you would have said, why, when the petitioner has made the application to enter their names in the katha register, you have not obeyed the directions of this court, which was issued earlier. And on the other hand, you have now entered the name of some other person without giving an opportunity of hearing to you.
Yes.
That would be illegal.
Right. Just two communications.
Yes.
I have not been put to notice, so I'm not able to produce. Only information I get is correspondence from the corporation. Kindly see at page 46 of the first correspondence. As in paragraph 3, page 46, annexure H.
Yes.
For the very first time, on 4th September 2014, there is reference to a claim by Mayala Rani.
Correct.
For the first time, I think you notice. Now, I have no direct information. What is the basis of Mayala Rani's claim?
Correct.
It's an act. I'm sure my lord will agree with me. The basic thing is they should tell me that on the basis on which Mayala, there is a right claim now.
That is why I am saying, if they had entered the name of this Mahila Mandali in the katha register, you could have come before this court and said, I have already made an application. There was a direction by this court, and instead of entering my name, they have entered the name of another entity.
Yeah.
My opportunity of hearing was not even given to me.
In fact, that situation did not arise because in annexure H, in 46 annexure H, they say that there are rival claims, go to court and get a resolved.
Correct.
That means both claims are at a cloud.
Correct.
So they cannot favor me, they
Yes.
cannot favor the Mahila Mandali.
Yes. Yes.
Right.
You're right.
Then what? Can we see annexure, the last annexure, what they do? They refer to, can we see page 51, annexure M.
Yes.
They say that the DC order is there. I'm not noticed, there's no copy of it, no date mentioned. On the contrary, the DC has written, they have pointed out the entire process are katha in accordance with law. I am not put to notice about the Mahila Mandali basis of claim, which the corporation initially claimed. So that is left out. Now they are looking at a third version. They say that the DC has reserved this property for.
Ambedkar.
I don't have the order. I don't have any information.
Correct.
Can you see that? The DC is also part of it. He needs some clarity. All I'm seeking is some clarity on the position. Then even my suit I discontinue if I don't have a right. I am scared now. Even the corporation is so convinced. The corporation is convinced that I have no right. And the basis on which they have decided, let them show me. And if I know for a fact that I have no right, inspector magistrate will deny me my right. All I see is what is the show me the DC order. What is the basis of the DC order? But this is an order. Kindly see page 51 annexure M.
Yes.
This is an order based on the DC order. The DC order is not communicated. It will not answer any requirements or principles of natural justice. This is the basic thing I need. What is the basis of which? Because the same DC earlier had written on my application to the panchayat to consider my application. Now after 2019, my lord saw the effect in 2012. After 7 years, they would endorse this. So contrary to their own 14 endorsement, the Mahila Mandali has taken the right. Now they say that they want to profit for Dr. Ambedkar. These are stances by the corporation, which are they be very careful to stand. Maybe there is genuine reason. As a party, I need to know. Now, on the basis of the sanction by the corporation, They are constructing the building for the Dr. Ambedkar Samudaya Bhavan. Knowing fully well that there is an issue on title, that action I admit. That the corporation should hold its horses, or they should say, we are sorry that you have no right. We are convinced that the Samudaya Bhavan should come up. Then you can do that. Everyone from solid material. All I think is protection until this katha not be endorsed with anybody name until the matter is called, and the corporation not act in favor of any party until this matter is resolved. With that extent, I would request the humbly request the court to consider. My lord, we are 5 petitioners, 6 sides. All of us have invested in this, and we are now threatened. All we seek to deal in work out our remedies. The corporation should just wait for the outcome of the litigation, having taken a stand that there is some list between the parties. All I seek, my lord, is right. That we get an abeyance for both parties, and the corporation not act as though A or B is the owner of the property until the matter. I would be grateful if my lord considers to that extent.
Learned HCDP takes notice for respondent number 4, Deputy Commissioner. Learned Counsel Shri Pawan Kumar, who is present in the court, takes notice for response number 1 to 3, BBMP. Notice to respond number 5 is not necessary for the following reasons. Next para. Matter is coming up for preliminary hearing. We'll stop. The grievance of the petitioner is that although there was a direction by this court in an earlier round of litigation in WP number 17134-17136 of 2012, dated 12th of June 2012, directing the respondent BPMP to consider the application of the petitioner for change of katha on the strength of a registered document, within an outer limit of 2 months from the date of issuance of a certified copy of the order, nevertheless, an endorsement came to be issued on 4/9/2014 at the hands of the respondent, Assistant Revenue Officer of the BBMP, stating that a counter claim is made on behalf of Mahila Mandali, stating that the properties in question, measuring 235 into 40 feet, has been granted for the purpose of construction of a community hall. Full stop. Therefore, the application filed by the petitioner for transfer of katha was not considered. Full stop. Next para. Learned counsel for the petitioner submits that in terms of the endorsement dated 4/9/2014, the petitioner approached the Deputy Commissioner, Bangalore Urban District, to seek clarification as to the allotment of the sites way back in the year 1979 and the subsequent claim made by another entity known as Mahila Mandali that the same property measuring an entire extent has been allotted for construction of a community hall. Stop. The Deputy Commissioner wrote to the executive officer of the Taluk Panchayat, Bangalore South Taluk on 25/3/2015, directing that it was claimed by some of the like the petitioners that in survey number 148 of Chikkabanaswadi village, Bangalore South Taluk, sites were formed for distribution to sightless persons, and it is claimed that some of the sites have been distributed to or allotted to the petitioner and some other persons. Full stop. The petitioner and the other such persons had approached the corporation for transfer of katha and issuance of NOC. Stop. Therefore, the executive officer of the Taluk Panchayat was directed to look into the matter and take action in accordance with law. Stop. However, even before any action could be taken by the executive officers, one more endorsement, namely the impugned endorsement dated 14/8/2019, was given by the respondent, Assistant Revenue Officer, stating that the Deputy Commissioner, Bangalore Urban District, has passed an order directing to establish Dr. B.R. Ambedkar Bhavan, Community Bhavan, in the land in question, and therefore the application filed by the petitioner for transfer of katha is rejected. Full stop. Next paragraph. Learned counsel for the petitioner submits that there are 3 writ petitions filed on the same cause of action. Full stop. Earlier too, all the 3 writ petitioners herein were the petitioners who had approached this court and had secured an order at the hands of this court directing the corporation to consider and dispose of the application for transfer of katha within a fixed time. Full stop. When the application for transfer of katha made by the petitioners were pending consideration before the corporation, new claims have been made. Full stop. Therefore, it was incumbent upon the respondent corporation not to have proceeded with the matter any further. Full stop. On the other hand, the corporation itself has started construction on the property in question. Full stop. Therefore, the petitioners have approached the city civil court and have filed an original suit in OS number
all of it are common order.
yes,
3053 to 3057 anything.
of 2023. A suit for seeking declaration that the plaintiffs are the owners of the absolute owners of the individual sites. Stop. Learned counsel would therefore submit that the respondent corporation should be directed not to proceed any further in respect of the construction as well as the katha. Stop. Next para. Per contra, learned counsel for the respondent corporation submits that if the construction has been commenced by the corporation, it can be only on the basis of the directions of the deputy commissioner, who has reserved, who it appears has reserved the property in question for construction of a community hall. Full stop. That being the position, learned counsel for the respondent corporation submits that no such direction can be given by this court in the matter of construction, since the repetition is concerning the registration or transfer of katha in favor of the petitioners. Full stop. Moreover, the petitioners have already approached the city civil court, filing original suits seeking declaration of title. Full stop. Therefore, if any directions could be issued, it is the city civil court to restrain the defendants therein from proceeding with the construction, pending the final decision of the suit. Full stop. Next para. Having heard the learned counsels and on perusing the petition papers, this court is of the considered opinion that since the grievance of the petitioners is pertaining to the transfer of katha in the office of the respondent corporation, the interim prayer made in the writ petition to direct the respondents or restrain them from commencing or proceeding with the construction on the properties belonging to the petitioners, cannot be granted. Full stop. However, in respect of the katha, the petitioners have not produced any document to show that the katha has been transferred in favor of any other person or entity. Full stop. Nevertheless, since it is alleged at the hands of the petitioners that the corporation itself has commenced the construction work, the respondent corporation is hereby directed that pending consideration of the application for transfer of katha made by the petitioners, the respondent corporation cannot transfer the katha in the name of any other person or entity. Stop. Since a suit for declaration is said to have been filed by the petitioners, the corporation also shall await the outcome of the suits insofar as the registration or transfer of the katha is concerned. Full stop. Next para, ordered according.
My right is
Yes, you should.
that is
You should.
these officers are not the way of needs.
Needless to observe that the petitioners have all the right to seek an order of temporary injunction restraining the defendants in the suit pending consideration before the city civil court. Full stop. The observations made herein above shall not prejudice the case of any of the parties before the civil court. First paragraph, I will change it so that I'll make it a common order. Yes. ಅದು one. ಇದನ್ನ ಬರ್ಕೊಂಡ್ first paragraph. Since the grievance of the petitioners in all the three writ petitions are common and directed against the respondent BBMP, these writ petitions are clubbed, heard together and disposed of by this common order. Yes. Yes. Huh? Lobby premises for what? Trade license. Madam, you can't be so naive. You can't come before this court and say, "Namgenu gottilla band lock hakkottidare." There has to be some information, madam. You can't make this kind of submission. There will be some notice issued. Something will be there. Otherwise, we'll only ask them to get instructions. If you don't bring the truth before this court, it is difficult for us to deal with this. Berkeley. Learned counsel Sri Pavan Kumar, who is present in the court, takes notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent BBN. Stop. Next para. Release this matter on 3rd of July 2023. Full stop. Learned counsel for the respondent BBMP is directed to secure instructions from respondents number 3 to 5 as to why they have locked the premises of the petitioner. Full stop. If there are any notices issued to the petitioner, the same shall be brought to the notice of this court. Yes. Huh? So you file objections. You will have to file objections and say, you will not file objection. A week's time is granted at the request of the learned counsel for the respondent to file statement of objections. Full stop. A copy of the statement of objections shall be served on the learned counsel for petitioner. Release this matter on 5th of July. Yes. Respond number 3. Some of them have been served. Or what are our Chandramohan? Mohan Chandra. This has not got to do anything with the other respondents in this. 9 also. Correct. Yes. 15. Or yes. For response 3 also. Who are the respondents in all these matters? Already. It arises out of what is the contract? Agreement of sale. You are the builder. You are the purchaser. And the respondents are? Yes. Yes.
So this is that as far as the point of view, no, nothing is mentioned in the agreement of. And the properties which they are scheduled properties which the relief is still, they are seeking a relief.
How is it that so many CMPs have been filed? Purchasers, I can understand there may be many purchasers. How about the respondents? All different transactions, right? Different transactions. Locality. Sorry, perfect. You serial number 15 ಅಲ್ಲಿ learned counsel Sri Syed Zahiruddin Barid, who has entered appearance for response number 1 and 2, undertakes to file wakalat for response number 3 also. A week's time is granted to do the needful. 14, 16, 17, 18, 19, 20 ಅಲ್ಲಿ a week's time is granted at the request of the learned counsel for petitioners to take steps for service of notice on the unserved respondents. Yes. 22 vargu. 22 vargu. 24 vargu. All right. Yes. But issue notice to the respondent. Next one, same, huh?
Next one is
Yes.
Supercast.
Agreement to sell. 2014. Huh?
Earlier also I filed a CAP where there was some information in the issue of notice.
The partnership is the owner of the property.
Yes. Here, page number 20. There was some information in the issue of notice, then
Where the arbitration clause?
page number 90, at class number 7.
Huh.
I got upon page number 31 in my notice.
Earlier also you had filed a CM.
Earlier there was some information in the issue of notice.
You had not invoked the arbitration clause.
Suggest for the arbitration. That was small information.
Hmm.
Notice also they did not respond.
Issue notice to the respondent.
It was allowed by an order dated 3/1/2020, which 105. The order the order directing the response, the restricting by an order. Taking third party right to the very problem. Then the competition article. Other mixture. The lecture E, lectures, page 129 and center, legal notice is a artist. But we also the arbitration clause on page 36.
Issue notice to the respondent.
Serial number 25. I represent respond number 5, my lords.
On filing of acknowledgement for having paid cost of fees 5,000.
This matter was earlier dismissed for non-prosecution. It was recalled with the condition that they had to pay cost of rupees 5,000 to the legal service authority members. They have not done it.
Matter is called out. There is no representation for the petitioner. Stop. Release this matter on 5th of July 2023 to enable the petitioner to file acknowledgement in the office regarding payment of cost as was directed by this court in its order dated 9/6/2023. Huh? Huh? Wakalat. Wakalat sir, ಇದು cost. Got it. Learner Council Sri DC Jagdish submits that he has been given an NOC Wakalat and the same will be filed in the office on behalf of the petitioner during the course of the day. So, Learned Council would also submit on 2/3/2023, cost of rupees 25,000 have been paid to the Bengaluru Professionals Benevolent Fund, and acknowledgement of the same shall also be furnished in the office. Stop. Release this matter on 5th of July. Office our ಹೆಸರು ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, office to verify and show the name of Learned Council in the cost list.
Serial number 27, I appear for the petitioner. I pray for a week's time to file the necessary application. The petitioner is in Bellary. She has sent the documents through courier. It has not yet reached us.
On filing of application.
I had to file an application to implead all the necessary parties, my lord, state and the
Yes, yes.
authorities and my neighbors. The application has been sent, signed and sent from Bellary. It has not yet reached us. I will file it within a day or two, my lord. Matter may be taken up next week. I had informed the respondent council also that I will be seeking an adjournment today.
One more week's time is granted. The petitioner, at the request of the Learned Council, for filing necessary application, as was observed in the order dated 15/6/2023.
Lord, interim order may be extended.
Granted earlier stands extended till the next date of hearing.
May I request a date to be fixed, my lord? Senior counsel has been engaged. I'm sorry, my lord. May a date.
So
be
not
fixed.
even filed application, sir. What is this?
My
You did
apologies.
file
my lord.
applications, we'll see.
Very well.
Huh? At the request of the Learned AGA, release this matter on 3rd of July. Yes. Interim order granted earlier stands extended till next date of hearing. Huh? ಯಾರು? Learned Council for the petitioners submits that the second respondent TMC, Piriyapatna, is represented by Allah. Is normally represented by its standing counsel, Sri M.B. Prabhakar. Stop. A copy of the writ petition has been served on the learned counsel. Stop. Next para. Office is directed to show the name of learned counsel Sri M.B. Prabhakar for respond number 2. Release this matter on 5th of July.
Lordship, serial number 25. Serial number 25, Lordship.
25 is over.
Lordship, we are ready to pay the cost for proxy counsel, Lordship. We are ready to pay the cost of 5,000 in 2 weeks.
You have directed the matter to be listed on 5th of July. Before that, you please do it.
Yes, Lordship.
Huh?
Okay.
IA 1 of 2023 for direction. Please have a copy on them, madam. Was filed IA for impleading. So Pradeep Savkar. ಹೆಂಗ್ರಿ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಏನೂ ಇಲ್ಲ. The counsel for the petitioner is once again requested to serve copy of IA number 1 of 2023 on the learned counsel for the respondents. Stop. Next para. IA 2 of 2023 has been filed by ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡೋದು? How can they do it like this? Even before order is passed, they have shown themselves as respondents. 8 to 22. 8 is the state of Karnataka. Tahsildar. So this application is filed by whom? Who are those applicants? But where is the details? What is this? Heldamma?
It has been filed.
Filed by the applicants seeking to implead themselves in these proceedings. So, however, name of the learned counsel for the applicant is not shown in the cause list. Stop. Next para. released this matter on 5th of July 2023, along with IA number 2 of 2023. Yes. Interim order granted earlier stands continued till the next date. Huh? Respondent, please come this way. Yes. Rectification of office objections raised on IA number 2 for impleading. Mr. H.E. Baswaraja, you are the, please serve a copy. Copy of IA number 2 of 2023 is served on the learned counsel for petitioner. What has not been learned to the transfer the katha in writing. The endorsement even means that there are two requirements pending to filed by the borrower. And until that is disposed of, it will not be. Now, who are these impleading applicants? Where is the question of making you a party, sir? The property has been auctioned. They have purchased the property. Huh? Huh? Except see page 26. They were there subject to payment of 30% of the amount. They were anyway, let them come, we'll see. Order on IA number 2 of 2023. This application is filed. I don't know what you don't even mention who are the applicants. Huh? Where have you mentioned in the application? Whom do you want to bring on record? The application alli. The previous application also was the same thing. Previous matter alli. You don't even mention who are the applicants. What kind of an application are you drafting? Huh? There. Mention ಮಾಡಿದಿರ application ಅಲ್ಲಿ. Whom do you want to bring on record? Huh? Learned counsel H.E. Baswaraja, appearing for the applicants in IA number 2 of 2023, seeks leave of this court to withdraw the application and file a better application. Full stop. A week's time is granted to do the needful. IA number 2 of 23 is accordingly disposed of. Release this matter on 5th of July. Huh? A week's time is granted at the request of learned counsel for petitioner to take fresh steps for service of notice on response number 8 and 9. Why all these other private respondents?
They have diverted the land from Rajkalve, they have closed the Rajkalve, and they are claiming independent right by way of sale deed. And they are ready to close.
Then how can you seek dispensation then?
Take for the action against.
ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Clear against the party. It's not a direct, the authorities has to take a legal action against the private respondent.
Even otherwise they are necessary. ಮತ್ತೆ how can you seek dispensation?
Because of urgency.
ಆಗೋದಿಲ್ಲ.
The authorities have.
Just because there is urgency, you seek dispensation, is it?
I give the representation to authorities.
You can say pending service of notice on those respondents, please consider my interim prayer. ಅಷ್ಟನ್ನ ಹೇಳಿದ್ರೆ ಸಾಲದಾ? ಮತ್ತೆ dispensation ಹೆಂಗ್ ಕೇಳ್ತೀರಾ? Yes. ಆಯ್ತು. BBMP.
These all survey numbers there was a repair of Rajkalve. Now these private respondents are going with the Rajkalve and they want to utilize this entire land and diverted the Rajkalve from the entire middle of the portion of the land. They have one side of the land they have to deal with the authorities and now they want to form the layout to sell the piece property. And it is affecting the rates of now in view of change of location and the one of the adjacent owner of the property.
ಎಲ್ಲಿದೆ? ವೆರಿ ದಿ sketch.
May kindly annex D page 35 may kindly look at that. Page number 35 annexed D2. The dotted two dotted line motions are there, blood.
Yes.
Second dotted line motion blood is survey number 62 bar 3, 62 bar 6, 62 bar 5 and 62 bar 4. This location is there. This entire dotted line second line. Now in 62 bar 4 the blood has diverted totally. You want to form the layout and sell the property third party by way of independent his cycle. Blood exactly in 62 bar 4 in almost 20% of land blood in one side and 80% of land is in one side. Block number 4 may kindly see that. Now that is
You are the owner. You are the owner of which property?
I am the owner of 62 bar
2.
1 bar 1B.
2 bar 1B.
2 bar 1. It is bifurcated and coded as 2 bar 1B. Photograph may be different blood also.
Yes.
Page number blood. Yes, 197 they started blood. Yeah, the boards to class for sale and they have day and night blood they are doing these activities and diverted the entire old structures inside the Kalve and constructed the north wall in the inside. Mustard ಮಾಡಿರುವಂತ page number 100 may kindly look at that. 100 ನಲ್ಲಿ photograph ನಲ್ಲಿ entire ಹೊಸ ಕಟ್ಟಡ ಕಟ್ಟುವುದು temporary compound wall.
But the Nala is there already.
That for that blood ಇಲ್ಲಿರೋದನ್ನು ಡೈವರ್ಟ್ ಒಂದ್ ಕಡೆ ಮಾಡಿದ್ದಾರೆ. ಎರಡನೇದು ಇವರು ಲಾಸ್ಟ್ ಕ್ಲೋಸ್ಡ್ ಕ್ವಶನ್ ಪೇಜ್ ನಂಬರ್ 100 and 101 may kindly look at two different angles. 100 page and 101. 100 you last may kindly see the new compound wall. And it is closed. And this is one side. But second is
Nala is running that side only.
As per the BBMP planning zone, master plan, village master plan, the rule is that 50, there are 3 types of zonal area has been divided. Last colony, primary, secondary, and
you are appearing for whom? Private respondent. All right. He is not claiming any right over the property. He is now saying, don't allow them to divert the existing nala. You madila antandre there is no difficulty. We'll consider.
This has been paid, making other respondents as a good for them. Yes, sir. They are having grievance against.
Whatever it is, we will find out from the BBMP whether they are diverting the nala. If there is no diversion, there is no difficulty.
That's not our objection in that regard.
Berkeley.
That regard. But whatever you wanted to see that.
Notice is already issued. 8 and 9 ನೀವು ತಗೊಳ್ಳಲ್ವಾ?
Only I am responding of 14.
All right.
Only for responding of 14.
Next para. Learned counsel for the respondent BBMP. Elri Jagdishwar avaru. He directed to secure instructions from the respondent BBMP as to whether there is any plan to divert the existing nala as has been contended by the petitioner. Stop. Release this matter on 5th of July. Or ಹೇಳ್ರಿ ಅವರ ಜಗದೀಶ್ವರ್ ಅವರು. ಅದು ಹೇಳಿದ್ದೇನೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಹೇಳಿದ್ದೆ. ಎಸ್
Another 4 lakh, 1,50,000 each apartment is not.
2 lakhs to be paid.
1,50,000 apartment. Another 50,000 yesterday. But the apartment is not good. Another 4 lakh before policies. Some money, some time. He has lost everything. Yes, no.
ಇವಾಗ ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ ಇದುವರೆಗೂ? ಇದುವರೆಗೂ ಬರೀ 2 ಆಗಲ್ಲ. ನಾವು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. At least if you had paid 50% of it, they also could wait for some time because it's a small amount, not a huge amount. ಏನ್ ಮಾಡೋದು ಇವಾಗ? At your request, we had given you a breather. Now, if you go on asking for time, what can we do? You go and ask them the time. We can't direct them. No, you keep quiet. Anta. Huh? Huh? But automatically vacate agogide. You see, if the sum of rupees 2 lakhs is not deposited by 30/3/2023, the interim order will stand automatically vacated. If the balance amount of rupees 4 lakhs is not deposited by 1/6/2023, the interim order will stand automatically vacated. It is vacated. You see what you have to do. In the meanwhile, if you want to make some more payment, you make it. At the request of the learned counsel for petitioner, release this matter on 12th of July. Yes. ಅಲ್ಲ ಅದಕ್ಕೇನೆ ಸಿ ನಾವೇನಾದ್ರು ಹೇಳಕ್ ಹೋದ್ರೆ it will be taken as if the earlier order is extended. That is why I have not said anything. ಯಾರ್ದು ರಿಪೋರ್ಟ್? ಯಾರ್ದು ರಿಪೋರ್ಟ್? ADLR. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಹಾ. ನಕ್ಷೆಯಲ್ಲಿ ABCDQ ಎಂದು ಗುರುತಿಸಿರುವ ಸರ್ವೆ ನಂಬರ್ ಗಡಿಯಾಗಿದ್ದು ಅದರ ವಿಸ್ತೀರ್ಣ ಸದರಿ ನಂಬರ್ ಸ್ಥಳದಿಂದ ಬಡಾವಣೆಯಾಗಿದ್ದು ಹಾಲಿ BBMP ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುತ್ತದೆ. ಕಾಲುವೆ ನಕ್ಷೆಯಲ್ಲಿ ಹಳದಿ ಈ ಗುರುತಿನಿಂದ ತೋರಿಸಿರುವ 40x30 ಅಡಿಗಳಲ್ಲಿ ವಾದಿಗಳಿಗೆ ಸೇರಿದ ಒಂದು ವಾಸದ ಮನೆ ಇದ್ದು ಸದರಿ ಮನೆ ಪೂರಾ ಕಾಲುವೆ ಜಾಗದಲ್ಲಿ ಇರುತ್ತದೆ. ಆ ನೀಲಿ ಕಲರ್ ಬಣ್ಣದ ನೀರು ಹರಿಯಲು ನಿರ್ಮಿಸಿರುವ 2 ವರ್ಷ ಹಳೆಯ 15 ಅಡಿ ಅಗಲದ ಡ್ರೈನ್. Yes, sir. Learned AGA has filed a memo dated 5/6/2023 along with an inspection report of the Assistant Director of Land Records, Bangalore South Taluk. It also consists of a sketch and markup. So a copy of the same is handed over to the learned counsel for petitioner. Stop. At the request of the learned counsel for petitioner, release this matter on 5th of July. Huh? ಇದೆ ಇದೆ. ಇದೆ. We'll consider. Yes. If it is clearly in the Kalve, we cannot help you. We'll direct them to demolish it. Yes. Yes.
Six is a 10 over. In paragraph A, he says that the typing is mistaken. This is the Monday. Even produce the sketch also.
Hmm.
As the director to learn, produce the sketch.
Ah.
That was the entire object is computer of the complex.
BBMP.
Also,
ಏನು what is the matter?
that's true. Initially, you manual sanction. And sanction. So, as per the sketch, you not be very appreciated. So, even like you will be they gave it to the road. So, Kacha road is the road. The million access is not to be able to get it. Because they want me to consider this as 18.4 meters. And the right hand is not 2.5. The access here on the east side, even less than 12 meters. Less than 12 meters. He wrote a main road in 12.4 meters. This is a mud road and a Kacha road. Actually, this is not Roma. Now, how I will consider this road to be a road and give them 18 points.
No. If it is like this, that there is only an access from the main road to this property. Under such circumstances, is it not permissible to take the main road as the ಹೌದು ಕೊಟ್ಟಿದ್ದಾರೆ ಹೌದು ಕರೆಕ್ಟ್ that is what I am saying. In law, can it not be said in these circumstances where there is only a short distance between the main road and the property, and it is only an access? In such circumstances, can the main road not be considered as the ಯಾವುದು ಅದಲ್ಲ ಮೇನ್ ರೋಡ್ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ ಅದ್ರದ್ದು ಹೇಳ್ತಾರ ನಾನು ಯಾವುದು there is no road there. It is only an access. Initially, they consider this portion, the portion or consider for the purpose of the affair. You don't consider 2.2. How you the outskirts are put in the 78.2. Other than now, if now they want me to consider this as 18 point, you have to do this thing, but 18.2 and towards the investment are only there. This is the access. In the product, if I get them 2.5, you have not achieved you won't access. You won't need the burden. Easy access. Pressure on the infrastructure. If you do west, you know, sustain. 150 apartments actually the chart. Draft ready ಇದೆಯಾ? Learned counsel for the respondent BBMP submits that statement of objection will be filed on behalf of the respondents on or before 3rd of July. Allala, it will be filed on or before 3rd of July. List this matter on 5th of July. 6th of July. Yes. Yes.
Under construction and was plot 5A. in respect to which an order was passed.
Where is the report? Report. ಇವಾಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Order preventing any further construction. But the addition pertains not only to plot 5A, but also to plot 6A to 6F, for which I have today procured sanction plan.
Huh? What?
Report pertains to plot 5A, which is under construction. There is an order protecting further construction. The petition pertains to not only plot 5A, but also plot 6A to 6F, where owners of the property have gone beyond the sanction plan. It is more than the sanction plan. Most sanction plan is but the property will be last week. Later on record, all these are and the report of the DVM should also extend to plot 6A to 6F.
You are a complainant.
And the petitioners, petitioner complaint had made representation stating that on plot 5A and plot 6A to 6F, the owners are going well beyond what is sanction limit. The 6 plots they have constructed above what is allowed. What was allowed is G plus 2, they have one constructed G plus 5. So to the worship you find my petition. At page 123 onwards.
ಹಲೋ ಇಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಈಗ ರೀಕೌಂಟಿಂಗ್ ದಮ ಹೋಗಿದ್ದಾನೆ
Sharma. No, where are the private respondents?
Private respondent was R9. R9 is the person with respect of whom the sanction plan for 5A was given, which I produced in
5A.
5A. Where there was an intent not to do further construction. Now, yesterday, I think given copies of the sanction plans for 6A to 6F, where construction is already complete, which Moto your worship will see at page 128. Correspondence to 6A to 6F. One sanction plan is passed, respondent 9, and the others are for other parties which are active in the provision of amend the petition and make them parties.
Who are you?
I am the petitioner. Or 6 petitioner.
I can't understand, sir.
I am the neighbor.
Huh?
I am the neighbor, neighboring partner. All the illegal constructions are taking place abutting my compound. Worship, we kindly have page 120 worship where my property lies.
Who is representing respond number 9? So, Raghunandan Reddy. Now you have to implead the other owners.
Yes.
Good. Learned counsel for the respondent BBMP has filed a memo along with report dated 21/6/2023 prepared by the assistant director town planning, BBMP Mahadevpura zone. So a copy of the same is served on the learned counsel for petitioner. What should be done now?
Your Lordship, for the Your Lordship, I represent respondent number 6 in the instant matter. We've already filed our reply. Bestcom, Your Lordship.
Bestcom.
Yes, sir.
Not possible. You have not even brought in the owners. Yes. Interim next para. Release this matter on 5th of July. Interim order granted earlier and extended till the next date of it.
Serial number 38, my lord. Serial number 38, my lord.
Yes.
I appear for respondent number 14. First,
Yes.
I am sorry, I unmuted earlier. I disturbed your lordship. Please excuse
Yes.
me. It is by mistake. Now, R14, the contest is between petitioner and R14 regarding the election. Now, this honorable court has already directed them to recount and submit a report. The report appears to have been submitted, and based on that, further orders have to be passed. Your lordship see the earlier order passed by this honorable court on 12th April 23, my lord. 12th April 23. They have to submit the report. It's only recounting ordered. Clause 5 of the order, my lord. Respondent number 1 to 4 are directed to recount the ballot. It was done, my lord, on 20th. I learned that recounting was done on 20th May.
20th May.
20th May recounting was done, and a report appears to have come. It has to be seen before by your lordship. I'm not able to hear my learned friend. I do not know what the report they have submitted.
Both of them have got equal votes. Copy was not directed to be given to you. ಅಲ್ಲ ಈಗ ಎರಡು ಈಕ್ವಲ್ ಅಂದ್ರೆ ಇನ್ನೇನು
ಈಕ್ವಲ್
ಹಾ No, he says the provision enables that if equal votes are secured by two contestants, then it has to be divided by toss.
Election declaration.
Adalla, now there is a direction by this court. A direction was given by this court. You have taken it, you are not objected to it. A direction was given by this court to do the recounting and submit a report. They have submitted. Yes. Yes. Copy.
I could not hear my lord, my learned friend. I'm sorry. I want to hear sorry.
ನಾನೇ ಹೇಳ್ಬಿಟ್ನಲ್ಲ.
ಅದೇ equal ಬಂದಿದೆ report.
Yes. Learned AGA submits that in terms of the directions given by this court, the recounting was held and the returning officer has forwarded the information to the learned AGA. Full stop. Learned AGA submits that the report shall be filed along with a memo in the office during the course of the day. Full stop. A copy of the same shall also be served on the learned counsels for all the other parties. Full stop. Release this matter on 5th of July.
5th, my lord. Very good.
5th. Interim order granted earlier stands extended till next date of hearing.
Right.
Matter is called out. There is no representation for the petitioner. ಏನ್ರಿ ನಿಮ್ದು ಹಂಗೆ ಇದೆಯಂತಲ್ಲ ಬಿಲ್ಡಿಂಗು, ಅವ್ರದ್ದು ಹಂಗೆ ಇದೆ, ನಿಮ್ದು ಹಂಗೆ ಇದೆಯಂತಲ್ಲ ಬಿಲ್ಡಿಂಗು, ಮತ್ತೇನ್ ಮಾಡ್ತೀರಾ? ಹ್ಮ್ ಅವ್ರಿಗೂ ಅದೇ ತರ ತಾಪತ್ರಯ ಇದೆಯಲ್ಲ, ಏನ್ ಮಾಡ್ತೀರಾ? we can't give any exemption for you just because you have left a small gap. ಆಗೋದಿಲ್ಲ. That is why he has said release this matter on 5th of July. Matter is called out. There is no representation for the petitioner. Full stop. Even on the previous occasion, there was no representation. Full stop. Next paragraph. Release this matter on 5th of July. Full stop. If there is no representation for the petitioner on the next date of hearing, the writ petition will be dismissed. Application and the senior member of the
was found in 1990. Allotments are made from 92 and onwards, about 2,800 sites are already allotted. The present board takes charge in the month of April 2023. So even before the present board had taken charge, but I made this officer as party. He appears to be a missing. Even before the elections were conducted and the special officer is in charge of this society, he initiates an inquiry under section 6. And then after we take charge, immediately after we take charge.
Point number 4.
When it's a party.
Joint Register of Cooperative Societies is named party EO nominee. So notice issue ಮಾಡಿಲ್ವಾ?
ಅದೇ hands over server.
ತಗೊಂಡಿದ್ದೀರಾ ನೀವು? Why there is no file with you? Response number 1 to 3 ತೋರಿಸಿದಾರಲ್ಲ. File ilva? Court respondent has been named EO nominee. And now they have served the hand summons on him.
This fourth respondent what it does very conveniently. 16/8/2021 he passes an order, court register. 31/1/2022, he then releases the order because then he sends a list saying that you shall allot the site to so and so members. Then again he passes an order on 24/2022. This is pertaining to the previous board. Which again he discharges on 21/5/2022. He sends 3 lists saying that you should allot the site to these members. On 15/6/2022 and 27/4/2022, he sends a list saying that you will have to allot sites to these members. There is no adjudication as such. Conveniently, he is passing orders. They stalls, releases. Stalls, releases. Now the order which is being passed by him is no member of the society has challenged the allotment made in respect of the 800 members. There is no dispute pending pertaining to this entire society. These are the allotments made from 1992 onwards. We are the body who have coming to April 2023. He directs that we should not register the sites in favor of the members. 1992 they have been waiting. He said that I have passed an order to section 64 based on which I do not want you to register the sites. That section 64 is subject matter of.
Even what did you submit? For what?
I am a permanent member of the society. If they have not prepared the CH-10, and moreover, some sites is to me.
That cannot be a dispute here, sir. We are not considered. You raise a dispute under section 70 if you want. The society is here making some allegations against the officer that they are he is not permitting them to allot the sites in terms of the bylaws.
Allotment is over.
Avರಿಗೆ permission ಕೊಟ್ರೆ ತಾನೆ ನಿಮಗೆ allot ಮಾಡೋದು. That cannot be considered in this writ petition, sir. ಯಾರು ಒಬ್ರು ಬಂದ್ಬಿಟ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳಕ್ ಬರುತ್ತಾ? Therefore, no, you need not even file application here. This is not a dispute that can be considered in this writ petition. They are only seeking a direction to permit them to allot the sites. Or allot ಮಾಡುವಾಗ ಏನಾದ್ರು ಅವರು ಇದನ್ನ seniority follow ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ then you will get a cause of action. Otherwise, where? ಅದಕ್ಕೆ ನೀವು dispute raise ಮಾಡಬೇಕು sir. How can you come and implead in this writ petition? Not possible. Even if you file such an application, it will be rejected. Anyway, you have not filed. Yes. Learned senior counsel, Shri D.R. Ravishankar, appearing for the petitioner, submits that hand summons have been served on respond number 4. So, the hand summons and acknowledgement of the 4th respondent in the hand summons have been filed along with a memo dated 28/6/2023. Full stop. Next para. Learned AGA is directed to inform the 4th respondent, who is the Joint Registrar of Cooperative Societies, named your nominee in the petition, since allegations are made against the 4th respondent. Full stop. Next para. Release this matter on 5th of July. We will dispose of the matter. Please get instruction. Huh? Illa.
This section 64 orders are challenged in WP number 12656 of 23. But in that petition, pass an order list along with WP number that is the present petition. Even that petition both the matters will be directly to the respondent.
Yavdo?
WP number 12656 of 23. It is passed on. But it already passed an order in that petition. Directing that petition to the listed on this.
Learned senior counsel brings to the notice of this court that in another writ petition filed at the hands of the petitioner society in WP number 12656 of 2023, by order dated 22/6/2023, this court had directed that this writ petition has to be listed along with the said writ petition. Stop. However, the said writ petition has not been listed. So, office is directed to take note of the directions given on 22/6/2023 in WP number 12656 of 2023. Full stop. Next para, relist both these matters on 5th of July. Is this matter after service of notice on respond number 3? Seven office objections are raised. 7. Madi. Learned AGA takes notice for response number 1 to 5. Issue emergent notice to respond number 6, returnable by 12th of July. Stop. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA. Stop. Next para. In the meanwhile, office objection should be complied with. Yes.
Item 44, your lordship. I am appearing on behalf of the petitioner, your lordship. I am on VC, your lordship.
Yes.
Lordship, due to one urgent matter being listed before the Honorable Supreme Court, before Justice Oka and Justice Vishwanathan, I am before the Supreme Court, your lordship. I seek little adjournment matter kindly may be listed on 3rd. I will be physical before your lordship to argue the matter, your lordship. 3rd July, lordship. This is my respectful submission, your lordship. Physically, I will be before your lordship to argue the matter, your lordship.
The CMP was allowed. These may they have made some allegations.
Yes.
Let it go on. Although the matter was adjourned on the previous date of hearing at the request of the learned counsel for petitioner, once again a request is made to adjourn the matter. Stop. List this matter on 12th of July 2023. Yes.
Lordship, lordship. Oblige, your lordship. Oblige.
Yes.
Serial number 45, my lord. Serial number 45, my name is shown for respondent number 2, but that is, my lord, executive engineer, NH division, PWD department. So, my lord, it's a state comes under state government and not NHI, my lord. So, my lord, government advocate would appear.
Learned AGA is directed to take notice for
R2. My lord, it is AGA also mentioned, AGA for R2, and my name is also for R2 as per causality.
Since learned AGA is appearing for respond number 2, executive engineer, comma, National Highways Division, comma, PWD, comma, the name of learned counsel, Srimati Shilpa Shah, may be removed from the cause list.
Obliged, my lord. Obliged.
Yes. 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 ನಿಮ್ದೇನಿದೆ? ಹಾ. ಹಾ. ಅದಕ್ಕೆ we had asked you, where is your plan when you had submitted? Huh? Huh? How can they sanction a plan like this, sir, without any setback? Huh? ಎಲ್ಲಿದೆ? ಎಷ್ಟಿದೆ ಸೆಟ್ಬ್ಯಾಕ್ ಸೈಡ್ ಅಲ್ಲಿ? ಕರೆಕ್ಟ್. ಸೆಟ್ಬ್ಯಾಕ್ಸ್ ಎಲ್ಲಿ ಎಷ್ಟಿದೆ? ಫ್ರಂಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಸೆಟ್ಬ್ಯಾಕ್ ಎಷ್ಟಿದೆ? ಹ್ಯಾವ್ ದೇ ಮೆನ್ಷನ್? ನಿಮ್ಮ ಬೌಂಡ್ರಿ ಎಡ್ಜ್ ಇಂದ ಸೆಟ್ಬ್ಯಾಕ್ ಎಷ್ಟಿದೆ ಬಿಲ್ಡಿಂಗ್ ಗೆ? ಇಟ್ಸ್ ಎ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್. ಕ್ಯಾನ್ ದೇ ಸ್ಯಾಂಕ್ಷನ್ ಇಟ್ ಲೈಕ್ ದಿಸ್? ಯಾವ್ಯಾವ್ದೋ ಡಾಕ್ಯುಮೆಂಟ್ಗಳು ತಂದು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ ಈಗ? No. Now, if they have taken action to clear all the Indian, what is the prayer in the writ petition? Huh? Washing. Huh? 80. ಹಾ ಹಾ ಮಧ್ಯಭಾಗದಿಂದ 21 ಮೀಟರ್ ಅಂತರ ಬಿಡಬೇಕಾಗಿರುತ್ತದೆ. ಸ್ಥಳ ಪರಿಶೀಲನೆ ಅಳತೆ ಮಾಡಲಾಗಿ ಈ ನಿವೇಶನವು 21 ಮೀಟರ್ ಜಾಗವನ್ನು ಬಿಟ್ಟರೆ ಉಳಿಕೆ 2 ಮೀಟರ್ ಜಾಗ ಮಾತ್ರ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ನೀವು ಕೋರಿರುವ ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡಲು ಅರ್ಹವಿರುವುದಿಲ್ಲ. You have already commenced the construction without obtaining building license. Please read the provision. Let us see. Municipalities Act. Please read the relevant provision which makes deemed permission. Yes. ಅದೇ 5 ನೀವು ಅದನ್ನ ಬಿಟ್ಟು 6 ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದೀರಾ. ಯಾವಾಗ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದು? ಅರ್ಜಿ $56. ಎಷ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ? Where is the plan for approval? How can it be?
The application declared itself.
ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ನಿಮ್ಮ ಇದು ಎನ್ಕ್ಲೋಜರ್ಸ್ ಇದು ವೇರ್ ಇಸ್ ಇಟ್? ಎಸ್ಟಿಮೇಶನ್ ಕಾಪಿ, ಟ್ರೇಸಿಂಗ್ ಶೀಟ್ ಮತ್ತು ನೀಲಿ ನಕ್ಷೆ 29/6/2018. Who is appearing for the municipality? Yes. ಏನ್ರಿ 2019 ಮ್ಯಾಟ್ರು? No, but see, please understand. If you read the provisions properly, that deemed permission, even if it is so, it can be only in accordance with the bylaws. It cannot be contrary to the bylaws. So therefore, I had asked you, what is the setbacks that you have shown in the front side? Whether it is in terms of the bylaws, you please point out on the ಹೇಳಿದೆ. ಹಂಗಲ್ಲ, ನಿಮ್ಮ ಇಷ್ಟ ಬಂದಂಗೆ ಮಾಡಕ್ ಆಗಲ್ರಿ ಎಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. Yes, what information do you have? ಯಾವಾಗ? 21/6/2019. 21/6. That is 1 year after the application is given. The applications are supposed to have been given on 29/6/2018. Annexure H ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲೇನೆ ಹೇಳಿದ್ರಲ್ರಿ, 3 ನೋಟಿಸಸ್ ಬಂದಿದೆ ನಿಮ್ಗೆ. ಯು ಕಾಂಟ್ ಸೇ ನೋ ನೋಟಿಸ್ ವಾಸ್ ಇಶ್ಯೂಡ್. ಅಲ್ಲೇನೆ ಆವಾಗ್ಲೇನೆ ಬರ್ಕೊಳ್ಳಿ. It is sought to be contended on behalf of the petitioners that since applications seeking building license were submitted by the petitioners in the month of June 2019 and 2018, ಬಟ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಅರ್ಜಿ ದಿನಾಂಕ 14/6/2019 ಅಂತ ಹಾಕ್ತಾರೆ ಅನಕ್ಷರ ಹೆಚ್ಚಲ್ಲಿ. There is no seal and signature. Seal and signature. No, anyway, we'll adjourn the matter.
It is ought to be considered on behalf of the petitioner that since the application seeking building license was submitted by the petitioners in the month of June
2018, and there was no order or notice coming from the side of the respondent municipality within the time stipulated. in section 187 of the Karnataka Municipalities Act, 1964, in terms of subsection 5 of section 187, there is a deemed sanction. Stop. However, learned counsel for the respondent municipality submits that the application was submitted only in the month of June 2019 and not 2018, as sought to be contended. Stop. Attention of this court is drawn to Annexure H, which is an endorsement dated 9/10/2000. Annexure H dated 21/6/2019. Allari, Annexure G alli, it is already rejected. October 2018. Huh? That is of the year 2019. Yes. 2019. They have left. Then why it was not sanctioned? Huh? 2 meters. So other bagge this endorsement is given. One.
The attention of this court is drawn to Annexure H.
Drawn to Annexure G, dated 9/10/2018. Stop. Learned counsel for the respondent municipality submits that the application filed in the month of June 2018 was rejected by issuance of the endorsement on 9/10/2018. Since the proposed plan did not comply with the requirement of leaving a building line of 21 meters from the center of the road. Full stop. Thereafter, subsequently, in the month of June 2019, again, applications for sanction of the building plans were again given by the petitioners. Full stop. In respect of those applications, one more endorsement for final order dated 21/6/2019 at Annexure H was issued by the chief officer of the municipality. Stop. It therefore sought to be contended by the respondent municipality that there cannot be any deemed sanction in view of the above. Full stop. Next para. At the request of the learned counsel for petitioner, release this matter on 5th of July. Please come prepared. 4th of July. Huh? Huh? Yes.
All charges are taken care. With that, you can verify that.
Solve sufficient.
Correct. Yes. Was held. Yes. Yes.
The senior inspector who has conducted the inquiry by giving notice of the deed, after the different intervals of time, we sought more and more clarification.
Yes.
I am reading available. Now the report is ready and it has been submitted to the joint director. Further action.
No, but you said you will file those documents.
I should be dealing with problem. I should be dealing with. All listing allegations, both allegations which he has not made, were once upon a time, they were the charges.
Copy of this has been given. You received a copy of this? Huh? Learned Counsel Sri R.A. Devanand, appearing for respondent number 5. Submits that these statement of objections are ready. So a copy of the same is served on the Learned Counsel for petitioner and the Learned AGA. So Learned Counsel is requested to file the same in the office during the course of the day. Full stop. Release this matter on 5th of July. Of course, if you file it today, it will come up. No. 10th of July. 10th of July. 8th. Who? We'll see. We'll consider. Yes. Yes.
I appear for petition, my lordship. My lordship, serial number 47, my lordship.
For impleading.
I'm representing advocate for proposed R4 and R5. We have filed
Yes.
the impleading application. We are the shareholders in the society, my lord. And any outcome of this liquidation also safeguards the share interest of the shareholders.
Liquidation.
Yes. Already proposal has been submitted for the liquidation.
My lordship, kindly pass out this matter, my
Challenge the
lordship.
validity of the liquidation.
To quash annexure A, B. Here is what is annexure A and B? Huh? How could these private individuals challenge that order?
We are shareholders in that society, my lord.
Allah, you are petitioner. Who is appearing for the petitioner?
Myself, my lordship. Kindly pass out this matter, my lordship. Kindly pass out this matter. As the senior counsel is engaged in another court, my lordship. We will furnish the documents of the resolution book and other balance sheets of the cooperative society, my lordship.
So the pleading applicants will be sailing with the petitioners.
No, we are. They are challenging the liquidation, and we are for the liquidation.
You are for the liquidation.
For the liquidation.
at the request of the learned counsel for the petitioner as well as the applicant in IA number 1 of 2022, released this matter on 5th of July for consideration on IA number 1 of 2022.
Much obliged.
Yes.
Much obliged.
After the matter was disposed of, you have filed this application seeking amendment. Here endorsement. Order. Huh? Here, what was the direction given? Huh?
Now, the division, the property now falls under the jurisdiction of Tahsildar Bangalore now.
It now comes within the jurisdiction of
Bangalore North. Tahsildar Bangalore.
Bangalore North Taluk. Or on IA number 2 of 2023. This application is filed seeking correction of the designation of the fourth respondent, Tahsildar. Stop. Learned senior counsel appearing for the petitioner submits that after the orders were passed by this court, when the petitioner approached the Tahsildar, Nelamangala Taluk for compliance of the directions issued by this court, the petitioner was informed that there has been a redesignation of the jurisdiction of the Tahsildars, and the property in question now falls within the jurisdiction of the Tahsildar Bangalore North Taluk. So therefore, learned senior counsel submits that this application has been filed seeking permission to amend the cost title and thereafter to issue a fresh certified copy showing the designation of the fourth respondent Tahsildar accordingly. Full stop. Next para. Learned AGA submits that he too has secured instructions, and it is true that subsequently the designation and the jurisdiction of the Tahsildars have been changed, have been modified, and the property in question now falls within the jurisdiction of the Tahsildar Bangalore North Taluk. Full stop. Next para. Consequently, the application is allowed. The petitioner is permitted to amend the cost title, showing respondent number 4 as the Tahsildar Bangalore North Taluk. Full stop. Next para. Office is directed to reissue a fresh certificate copy showing the designation of the fourth respondent accordingly after amendment of the cost rate. ಪರವಾಗಿಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ನಾಟ್ ನೆಸೆಸರಿ. ಹಾ, ಡೆಲಿಗೇಷನ್ ಆಗಿದೆ. ಅವ್ರು ಒಂದು ಕಾಪಿ ಕೊಟ್ಟು. Yes. It would have done, sir. They would have done that. Yes. That may not be the only contention of yours. All right. Yes. Yes.
On the basis of compromise and clearly goes to show that matter has been compromised between the party and compromise. It has been passed on the cancel the earlier sale date in the respect of the property in question. So, responding has slightly allowed the complete land limited matters in the
That reason is there in the found in the order, is it? Correct. That reason is found in the order. So ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? The assistant commissioner has taken note of that one. ಮತ್ತೆ
I have been holding titles in 1911.
But if you have concealed certain relevant facts and you have approached this court, then this court will have to come down heavily. He is now showing the doc. You have entered into a compromise ಅಂತ ಹೇಳ್ತಾರದ ಅವರು. ಕೊಡಿ, ಕಾಪಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ.
I don't have the knowledge of this. And among the death of my mother, they are holding the
Yes, please give a copy of this memo to the learned counsel. Learned counsel for respond number 1 has filed a memo dated 28/6/2023 along with copies of the judgment and decree passed in OS number 635 of 635. ನೀವು ಬರ್ದಿರೋದು ಮೆಮೋದಲ್ಲಿ ಬರ್ದಿರೋದು ಆ ತರ 635 ಇರೋದು. of 1963. 635 of 1963. ಯಾವ ತಪ್ಪಾಗಿದೆ? ಕಾಪಿ ಇದೆ ಇಲ್ಲಿ, ಕರೆಕ್ಟ್ ಆಗಿದೆ. 635 of 1963. ಅಲ್ಲಿ ಇವ್ರ ಹತ್ರ ಕೊಡುವಾಗ ತಪ್ಪು ಮಾಡಿರ್ಬೋದು ನೀವು. 635 of 1963. Passed by the second additional Munsif. ಯಾವ ಊರದು? ತುಮಕೂರು. ಮುನ್ಸಿಫ್ ತುಮಕೂರು ಅಂತ ಬರೆದಿದ್ದಾರೆ.
Even in the order of the AP, mentioned that but there is no protection to the order of law. And there is no
ಫರ್ನಿಶಿಂಗ್ ಕಾಪಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. No, anyway, you please serve a copy. That's all right. A copy of the same shall be served on the learned counsel for petitioner. It is the contention of respondent number 1 that the plaintiffs have entered into a compromise in the suit. ಅವರು ಡಿಪೆಂಡೆಂಟ್ಸ್ ಅದರಲ್ಲಿ, ದೇ ಆರ್ ಡಿಪೆಂಡೆಂಟ್. ಯಾರಿದು? ಅಹಮದ್ ಖಾನ್, ಇಬ್ರಾಹಿಂ ಖಾನ್, ಈ ಖಾನ್, the contention of the respondent number 1 that the petitioner's father was a defendant in the suit. ಎಲ್ಲಿದ್ದಾರೆ? ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಯ್ತು, ಪೆಟಿಷನರ್ಸ್ ಕಡೆಯಿಂದ ಹೇಳಿ.
It is the contention of the respondent number 1 that the petitioner's father, who was a defendant in the suit,
has given up his right in respect of the suit schedule property in terms of the compromise petition. Stop. However, learned counsel for the petitioner submits that the petitioner's father was not a defendant in the suit and the allegations sought to be made is incorrect. Full stop. Next paragraph. Insofar as the submission of the learned counsel for petitioner, which was recorded on the previous occasion, that the assistant commissioner was not empowered to pass an order under section 306 of the Karnataka Municipalities Act, 1964, the learned AGA submits that the power conferred on the deputy commissioner under 306, section 306, has been delegated to the assistant commissioner by a notification issued by the state government. What are the notification dated 9/1/2015? Yes. Next paragraph. Release this matter on 5th of July. I said he has to serve. Yes. You please do it today itself. Yes. Amendment. Huh? You have filed an application for amendment. The matters come up today.
Now, at present, it has been completed, and we have obtained the electricity connection. We have inclusion of the sector of so that is the reason I filed an amendment application to incorporate in the time of petition. I was not aware of the information at petition is a last one in the act 2020. That is the reason we have incorporated the provisions and the grounds for meeting the
What is the use of your simply saying that there is a deeming provision? When did you file the application? Huh? Annexure K. You have stated in your memorandum of petition.
The application has been submitted to the commissioner. There should be more representation to the chief commissioner and this is as the manager. They cannot bring this.
Or on year number 1 of 2023. This application is filed by the petitioners seeking permission to amend the memorandum of petition by adding paragraph number 8A, additional grounds and an additional prayer. Stop. Next paragraph. Learned counsel for the petitioner submits that although it was stated in the memorandum of petition that the petitioners had filed an application on 24/3/2021 seeking approval of the plan for putting up construction, nevertheless, no orders were passed and no notice was issued. Stop. Learned counsel submits that there is a provision contained in section 243 of the BBMP Act, 2020. Our submission. You will get an opportunity to file your objections. Please file. Amendment ಅಷ್ಟೇ ಇದು. Making provision for deemed sanction of the plan under certain circumstances. Stop. These aspects of the matter is sought to be brought on record by way of an amendment. Stop. Next paragraph. The submission of the learned counsel for petitioner is accepted. Stop. Application is allowed. Petitioners are permitted to amend the memorandum of petition by furnishing an amended writ petition. Stop. Copy of the amended writ petition shall be served on the learned counsel for the respondent BBMP. Stop. Statement of objection file madila alva ನೀವು ಇನ್ನು. Next para. 2 weeks time is granted at the request of the learned counsel for the respondent BBMP to file statement of objections. Yes. Interim order granted earlier stands extended till the next date of hearing. Yes. W. X and W. Where that order, what order of repetition was that one? Huh? Huh? Ah, yes. I remember I asked you, what is your locus? That is not enough, sir. A co-option is only a temporary arrangement. No statutory rights will vest in you. Yes. Yes. Correct. Correct. Yes. Anyway, what is that order? Writ petition order? You had filed the writ petition earlier also? No, on the previous occasion also you had challenged the same thing. What happened? No, what happened, sir, in that order? Venkataramana. Venkatarama. You are not the writ petitioner there. Yenanta? You are Venkatarama. For what? To consider as representation.
On the date of the death of the previous director, they remained 2 years, 11 months.
Correct.
But even though they were 2 years, 11 months, they did not under the election without.
Yes. What happened in that order, sir? And having perused the petition, this court is inclined to grant a limited indulgence in the matter inasmuch as where a citizen makes a representation ventilating his grievance, the jurisdictional authorities are bound to consider the same. And this having not happened, petitioner is more than justified in knocking at the doors of this court. Petition is disposed of directing response number 2 and 3 to consider petitioner's subject representation and inform him of the result. W. All right. Adadmele. Aito. Annexure W is the order. Annexure X. To the petitioner. ಇವರನ್ನು ನಾಮನಿರ್ದೇಶನ ಮಾಡಿಕೊಳ್ಳುವ ಮುಖೇನ ಭರ್ತಿ ಮಾಡಿಕೊಂಡಿರುವ ನಡವಳಿಯನ್ನು ರದ್ದುಪಡಿಸಿದೆ ಹಾಗೂ ಖಾಲಿರಿಕ್ತ ಸ್ಥಾನವನ್ನು ಚುನಾವಣೆ ಮುಖಾಂತರ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಿದೆ. ಆಲ್ರೆಡಿ ವಿಲ್ ಕನ್ಸಿಡರ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ ಅಟ್ 2:30. Yes. Allah, now we can't adjourn the matters. 54. Final hearing matters reach agade kashta. ನಾವು ರೀಚ್ ಆಗ್ತಾ ಇರುವಾಗ ನೀವು ಯು ವಾಂಟ್ ಟು ಟೇಕ್ ಟೈಮ್. ಲೆಟ್ ಅಸ್ ಸಿ. ಇವಾಗ ಅರ್ಜೆಂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ಪ್ಲೀಸ್ ವೇಟ್.
Court officer.
Court officer, madam. Firstly, serial number 56 adjourn ಆಗಿದೆಯಾ madam? Court officer, madam. ಹಲೋ ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದ್ಯಾ?
ಹೇಳಿ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 56 ಅರ್ಜನ್ ಆಗಿದೆಯಾ ಸರ್?
ಇಲ್ಲ ಇದೆ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ 230 ಮೂವ್ ಮಾಡ್ಬೋದಲ್ವಾ? ಹಲೋ ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ.
230 ಟೈಮ್ ಕೇಳ್ಬೋದಾ? ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೋತಾರ?
ಆಪೋಸಿಟ್ ಇರ್ಬೇಕು.
ಅಲ್ಲ ಅಪೋಸಿಟ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀನಿ ನಾನು.
ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರೆ ಕೇಳಲ್ಲ ಮೇಡಮ್. ಆಪೋಸಿಟ್ ಇರ್ಲೇಬೇಕು. ಒಂದೇ ವಿಸಿಲ್ ಇರ್ಬೇಕು, ಇಲ್ಲ ಪ್ರೆಸೆನ್ಸ್ ಇರ್ಬೇಕು ಇಲ್ಲಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ಇದಾರೆ 230 ಇರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅದಕ್ಕೆ 66
ಹೇಳಿ
ಕೇಳ್ಬೇಕು.
ಇದ್ರೆ ಟ್ರೈ ಮಾಡಿ.
ಓಕೆ.
ನಂಜಪ್ಪ ಸರ್ ವಿಡಿಯೋ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನೀವು ಕಾರಲ್ಲಿ ಡ್ರೈವ್ ಮಾಡ್ತಾ ಇರೋದು ಕಾಣಿಸ್ತಾ ಇದೆ.
Huh? The Bhaskar. There's another. I don't adjourn the matters unless the other side is here. That is my policy. No, Angidra will adjourn the matter when it reaches. All right, yes. You can move a memo anytime you want. What is the urgency? What do you want now? Friday. I don't adjourn the matter, sir. Please wait. No. Let us see. Yes. Judgments. The Supreme Court has held in Yeshwant Boyer. Supreme Court judgment on the question of locus standi. The complainant has to establish that he has been deprived of or denied of a legal right and he has sustained injury to any legally protected interest. In case he has no legal peg for a justiciable claim to hang on, he cannot be heard as a party to a list. Sir, what is your legal right to come and stand before this court and say, look here, I have a legally protected right. It cannot be taken away. You are only appointed as a stopgap arrangement, sir. You will not get any legal right. He is not setting aside your co-option. He is only following the directions of this court that in terms of the provisions, you are required to conduct election. Please conduct it. Adanna neevu, it cannot be heard from your mouth. You have no legal right. Please read the provision. It is under section 29E. You have been co-opted. Because there was a vacancy created. On account of some reason, a vacancy was created in the directorship of the society. Adikke, the second proviso reads as follows. Provided further that the board may fill up casual vacancy of the board by nomination out of the same class of members in respect of which the casual vacancy has arisen till the election is held for such vacancy. So, till the election is held for such vacancy, a co-option has to be made so that a gap is filled. Aste, you are only a temporary arrangement. What right has been vested in you to say, no, I should not be removed? Yes, under these provisions. Yes. Huh? Yes.
Now, the authority has not gone to
where is the question of removing you, sir? It is not removing you. They are required to conduct election. Not correct. You know all that.
And that expert on the following 10 crore. And by that time, the bid of the remaining term amount was less than crore. Therefore, file number 60 is also.
ಬರೋದಿಲ್ಲ. ಹಂಗ್ ಬರೋದಿಲ್ಲ. The vacancy has to be counted from the day when the vacancy arose.
The date of death.
That is not to be counted. Invariably, time has to be provided for that. But yes, I Barkal. On the other side, government advocates appearing for authorities have to come prepared. You know what is the issue that is going to be considered. You should come prepared to assist the court. ಪ್ರತಿಯೊಂದು ನಾವು ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ. On the last occasion itself, I had asked him this question. You should have come prepared with judgments. The petitioner is aggrieved of the impugned order dated 18/3/2023 at Annexure W, passed by the Joint Registrar of Cooperative Societies. Bangalore. And the impugned communication dated 28/3/2023 at Annexure X, made by the secretary of the sixth respondent cooperative society, wherein the petitioner was co-opted as a director of the board. Stop. Next para. Vacancy was created in the directorship of the board of the sixth respondent cooperative society on expiry of one of the directors, namely Sri M.S. Ramanna, who died on 1/3/2021. Stop. In terms of the provisions contained in Section 29E of the Karnataka Cooperative Society Act of 1959, since the remainder of the term of office was more than half of the original term, the society addressed a letter dated 16/4/2021 to the second respondent, election authority, for appointing a returning officer to conduct the election, to fill up the vacancy, casual vacancy, full stop. The election authority appointed the third respondent as the election officer, returning officer, election officer, election officer, who in turn appointed the fourth respondent as the returning officer to conduct the election to fill up the casual vacancy. Full stop. Calendar of events and announce ಮಾಡಿರಲಿಲ್ಲ. However, due to a general circular issued by the state government, noticing the difficulties created on account of the COVID-19 pandemic, it was directed, the election authority directed that elections in the cooperative societies shall not be held for a period of 6 months. Stop. Thereafter, ಯಾವಾಗ ನಿಂದು ಕೋಆಪ್ಷನ್ ಆಗಿದ್ದು? 16/12/20. 16/12/20. (28/12). ಅಲ್ಲ where is that order? R3. ಯಾರು? ಯಾಕೆ ನೀವು ಫೈಲ್ ಮಾಡಿಲ್ವಾ? ಇವ್ರು ಫೈಲ್ ಮಾಡಿಲ್ವಾ? However, by a resolution dated 16/12/2022, passed by the sixth respondent, society, the petitioner was co-opted as a director to officiate as the co-opted director of the board in the vacancy. Stop. Next para. In the meanwhile, the fifth respondent herein approached this court in WP number 12747 of 2021, seeking a direction to the Registrar of Cooperative Societies to consider his representation and nominate the petitioner as the director in the to fill up the casual vacancy. Full stop. This court, by order dated 17th of November 2021, held that where a citizen makes a representation ventilating his grievance, the jurisdictional authorities are bound to consider the same, and such consideration not having taken place at the hands of the concerned authorities, the writ petition was disposed of, directing the Registrar of Cooperative Societies to consider the representation and inform the petitioner therein of the consideration of the representation within a period of 4 weeks. Stop. In fact, it was also directed that till then, the matter should not be precipitated. Stop. ಏನು ಡೇಟ್ ಹೇಳಿದ್ನ ಇದ್ರದ್ದು resolution passed by the society. So in spite of a direction that it should not precipitate the matter, that resolution was passed. Next para. Since the petitioner herein was co-opted as a director by a resolution dated 16/12/2022, in spite of a specific direction being given by this court in writ petition number 12747 of 2021, dated 17th of November 2021, that till the representation given by the petitioner therein was considered, the matter shall not be precipitated, nevertheless, since the petitioner was co-opted, the fifth respondent once again approached the Joint Registrar of Cooperative Societies. Correct, Tane? Joint Registrar, Tane? No. He has filed appeal. Venkatrama. Huh? What happened?
Even there, they complained.
That's all right. In the meanwhile, there was a complaint again given by the fifth respondent to the Joint Registrar. Adallappa. 13-2. Either the contempt court the order either idea. What is
Since the petitioner was co-opted, the fifth respondent once again approached the Joint Registrar of Cooperative Societies.
Once again made a complaint before the Joint Registrar of Cooperative Societies on 13/2/2023. Betting his grievance that the petitioner herein was co-opted as a director, contrary to the directions issued by this court. Stop. The fifth respondent also filed a contempt petition in CCC number 185 of 2023 before this court. Stop. During the course of the contempt proceedings, the Joint Registrar of Cooperative Societies considered the complaint made by the fifth respondent and passed the impugned order dated 18/3/2023 at Annex W. Stop. Reference is made to the orders passed by this court in WP number 12747 of 2021. Stop. Having regard to the provisions contained in section 29 capital E, and more particularly the second proviso, the Joint Registrar directed that elections shall be held to fill up the casual vacancy created in the directorship of the board on account of the death of Sri M.S. Ramanna. Stop. Following the same, the secretary of the sixth respondent cooperative society made the impugned communication dated 28/3/2023, bringing to the notice of the petitioner the decision of the board to cancel the co-option made in favor of the petitioner, since elections are to be held to fill up the casual vacancy in terms of the directions given by the Joint Registrar of Cooperative Societies. Full stop. Next para. At the outset, objections were raised at the hands of the fifth respondent and the sixth respondent society regarding the locus standi of the petitioner in filing this writ petition. Full stop. The learned counsels submitted that the petitioner, having been co-opted as a director in terms of the second proviso to section 29 capital E of the Act, his co-option as a director was only a temporary arrangement to fill in the gap until elections are held and a director is appointed, filling up the casual vacancy. Full stop. That being the position, no legal right vested in the petitioner to challenge such an action on the part of the respondent authorities in directing elections to be held to fill up the casual vacancy. Full stop. Next para. You have any judgments you want to cite? Do you want to cite any judgment or what? Is there any submission that you want to make regarding your locus standi? Huh? On the previous occasion, the matter was adjourned at the request of the learned counsel for petitioner to enable him to answer the objections raised regarding the locus standi of the petitioner. Full stop. Today, the learned counsel for the petitioner submits that in terms of the first proviso to section 29 capital E, election could be conducted to fill up the casual vacancy only if the remaining term of the office is more than half of the original term. Full stop. The learned counsel would therefore submit that since the elections could not be held, admittedly, on account of several interventions, including the general circular issued by the state government, followed by the instructions given by the election authority, and by the time the ban was lifted and elections were permitted to be conducted, the remainder of the term was definitely less than half of the original term. Full stop. Therefore, it is sought to be contended that the Joint Registrar of Cooperative Societies could not have directed that elections should be held to fill up the casual vacancy. Full stop. Next para. Having heard the learned counsel for the petitioner, ಅದೆಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. ಈಗ ಇವಾಗ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದಾರಲ್ಲ, ಇವಾಗ ಉಳಿದಿರೋದು it is less than 1.5 years now, so it is definitely not more than half of the original term. ಇವಾಗ ಇಲ್ಲಿ ಎಲೆಕ್ಷನ್ಸ್ ನಡಿಬಾರದು ಅಂತ, that is the submission. ಹೇಳ್ದೆ. The learned counsel for the respondents, and on perusing the petition papers, this court is required to consider the preliminary objection raised at the hands of the learned counsels for respondents number 5 and 6 regarding the locus standi of the petitioner, our society. In fact, new raise madilla. I'm just putting it in your mouth aste.
Court is required to consider the preliminary application raised at the hands of the Learned Counsel for respondent number 5 and 6 regarding the local standing of the petitioner.
In filing this writ petition. Full stop. In Ravi Yashwant Boyer versus District Collector, Raigad and others, bracket 2012, close 4 SCC 407, the Honorable Apex Court, while considering the question of locus standi, of a complainant at whose instance action was taken against a councillor of the municipal council, held that the complainant has to establish that he has been deprived of or denied of a legal right and he has sustained injury to any legally protected interest. Stop. In case he has no legal peg for a justiciable claim to hang on, he cannot be heard as a party in a list. Stop. It was held that a fanciful or sentimental grievance may not be sufficient to confer a locus standi to sue upon the individual. Stop. There must be injuria or a legal grievance which can be appreciated and not a stat pro rationale voluntas reasons, that is a claim devoid of reasons. Stop. It was held that a person having a remote interest cannot be permitted to become a party in the list, as the person who wants to become a party in a case, has to establish that he has a proprietary right which has been or is threatened to be violated, for the reason that a legal injury creates a remedial right in the injured person. Stop. Next para. Following the said decision in Ravi Yashwant Goyal, bracketal Supra, the Honorable Apex Court, in the case of Ayub Khan, Noor Khan Pathan versus State of Maharashtra and others, bracketly 2013, close 4 SCC 465. Further held that a stranger cannot be permitted to meddle in any proceedings unless he satisfies the court that he falls within the category of aggrieved persons. Stop. Only a person who has suffered or suffers from legal injury can challenge the action for order in a court of law. Full stop. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the writ petitioner that there has been a breach of statutory duty on the part of the authorities. Full stop. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which writ jurisdiction is resorted to. Full stop. It is implicit in the exercise of such extraordinary jurisdiction that the relief prayed for must be one to enforce a legal right. Full stop. In fact, the existence of such right is the foundation of the exercise of the said jurisdiction by the court. Full stop. Next paragraph. Having regard to the principles explained by the Honorable Apex Court, this court finds that in the present context, the co-option of the petitioner as director of the sixth respondent society was in terms of the second proviso to section 29 capital E of the Act. Stop. The provision provides that if any vacancy in the office of the members of the board of a cooperative society by reason of death, resignation, removal, or otherwise, shall be filled up in such manner as may be specified in the bylaws of such society. Stop. The second proviso provides further that the board may fill up casual vacancy of the board by nomination out of the same class of members in respect of which the casual vacancy has arisen, single unit commas ಅಲ್ಲಿ till the election is held for such vacancy, close unit commas, bracket ಅಲ್ಲಿ emphasis is applied. Stop. Next para. Tapping the position, comma, the co-option of the petitioner to filling the casual vacancy is only a temporary arrangement till elections were conducted to fill up the casual vacancy, comma, in accordance with law. Stop. Therefore, comma, the co-option of the petitioner is only in terms of the provision of law. Stop. No legal right is vested in the petitioner to seek continuation of the petitioner in the said post, contrary to the provision of law. Stop. In terms of the provisions of the law, comma, as and when elections are conducted to fill up the post, comma, the elected member will take charge in the vacancy and the petitioner has to give way. Stop. Therefore, the petitioner definitely has no legal right to contend before this court or raise a contention that the remainder of the term being less than half of the original term, comma, no elections should be conducted and the petitioner should be permitted to continue as the co-opted member for the remainder of the term of the board. Stop. In the considered opinion of this court, comma, the petitioner does not have any vested interest, comma, he has no legal right to contend before this court that elections should not be held to fill up the casual vacancy. Full stop. Next para. Having regard to the principle expounded in the two decisions cited herein above, comma, this court is also of the considered opinion that no locus standi is available to the petitioner to maintain this writ petition. Stop. Next para. Consequently, the objections raised at the ends of the learned counsels for response number 5 and 6 regarding the locus standi of the petitioner is upheld. Stop. Next para. The writ petition is accordingly dismissed. Full stop. Ordered accordingly. Huh? ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಬರ್ಕೊಳ್ಳಿ learned counsel Shri PM Lokesh submits that he has filed wakalat for respond number 6 society. Full stop. Office to verify and show the name of the learned counsel. Hmm. Hmm.
Segregation or processing, only collection, transportation. That is how.
ಅಲ್ಲ ರೀ, ನೀವು ಹಂಗ ಹೇಳಿದ್ರೆ I will only record your submission and dispose of the writ petition, but you will not be permitted to anything there. Why do you want to make that kind of a submission? If it is permissible for the BBMP to collect the solid waste and keep it in a particular place, in a designated place in every ward, and thereafter it will be transported to the designated area, landfill sites. Should you not seek directions from this court that this kind of an objection cannot be considered? Why do you want to give up? Then that is regarding ownership. We are not concerned about the ownership here. You want to defend your action, you please defend it. Otherwise, I will record your submission and dispose of the matter. You will not be able to do anything further there. Two weeks time is granted at the request of the learned counsel for petition respondent BBMP to file statement of objection. Full stop. Release this matter on 12th of July.
Because they are our instructions are that they are undertaking erection of residential.
That will only be a building.
Yes.
In 2 weeks, nothing is going to happen. You will see. Yes.
But I got it. But it was filing motion for the Karnataka appellate tribunal. The Karnataka appellate tribunal on the limited scope, whether the notice is served on the borrower or not. With regard to other aspect of the matter, it did not decide the matter. The only short point that was decided by the KT is not that the notice which was sent to the borrower from the joint register of cooperative society. Intimation was delivered and was not paid. That is what this thing is. Before the KT, there are several other grounds with regard to the liability as well as the payments were also raised. That aspect was not considered. And consequently, the appeal came to be dismissed. But now, a CH-10 has been issued. Even during the pendency of the appeal before the KT, the interim order that was collected in to be deposited, I have complied with that.
How much?
50 lakhs are paid.
50 lakhs.
Well, connection B. This well connection B payments from P4 2020 after the award in the year 1990. Around 10 lakhs, 15 lakhs, and 22 lakhs, 50,000 rupees has been paid. If my lordship can see the award at page 11, page 11, we can see. Page 11 for a moment. Page 11 again.
Yes.
Second paragraph. For 50 lakhs, I have deposited, payment to the impact. Now, my lord, after the decision of the order by the AID, my lord, now my first proclamation has been issued by the bank, section E, page 24. Lord, if my lord could kindly see at page 25, I kindly receive. Again, for the same amount, my lord, they have added a column number, my lord, of code. So for the same amount, my lord, they have issued the proclamation. And apart from that, my lord, the rule 17 of the Karnataka law rules. The reason is, my lord, the reserve price, it is the mandatory requirement as per the rule, has not been mentioned in the same notice. That is the lord, I am before your lordship. What should I see, my lord?
The last payment that you made was on 21/8/2021.
Please. Isn't everything spent? Since because of COVID and other things, between that period, I have managed to pay that much. Residential premises for that reason. This honorable court. The legal aspects of this proclamation is starting now. Before getting the confirmation of 217.
No interim orders will be passed without payment, sir. Yearly, how much are you going to pay? In short period. The last, that's what I said. The last payment you made was in August 2021.
And also in search of COVID. During that period, I managed.
Adalla bala hinde agoytu. That was in August 2021.
That search also cannot I managed to pay that.
Please tell me, sir, how much are you going to pay now? No interim orders without payment. Not possible. ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ. At that rate you are not going to pay. You should tell us, sir. You should tell us. Otherwise, we will simply issue notice. You please tell us, sir, how much are you going to deposit? Within a period of 2 weeks now, how much are you going to deposit? Next 4 weeks, how much are you going to deposit? You please say. Then at AGA takes notice for response number 4 and 5. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA. Issue emergent notice to respondents number 1 to 3. Last sentence. Learned counsel Sri Narayan Babu DN has entered appearance for respondent number 1. Cooperative society. Why do you want to send notice to this 2 and 3? Who are they? Please file a memo. Learned counsel for the petitioner has filed a memo. Dated US and data stating that respondents number 2 and 3 are the guarantors, while the petitioner is the principal borrower. Stop. Therefore, since no relief is claimed against respondents number 2 and 3, the learned counsel prays that notice to respondents number 2 and 3 may be dispensed with. Full stop. Next para. at the risk of the petitioner, notice to respondents number 2 and 3 is dispensed with. Next paragraph. Learned counsel for the petitioner submits that after the award was passed by the competent authority and during the admission of the appeal before the Karnataka Appellate Tribunal, the petitioner has paid in all a sum of rupees 50 lakhs, 49 lakhs 25,299 to the first respondent cooperative society. Stop. The learned counsel submits that the award passed in favor of the first respondent society was in a sum of rupees 1 crore 44 lakhs 33,882. Stop. The tribunal has noted the amounts paid by the petitioner during the course of the proceedings. Stop. Nevertheless, in the impugned auction notice, again a sum of rupees 1 crore 44 lakhs 33,882 is shown as the outstanding amount. Stop. Moreover, the society has not followed. The society and the competent authority, fifth respondent, have not followed the provisions governing the issuance of auction notice. Full stop. No information is provided regarding the value of the property to show the reserved price, which is mandatory in terms of the provisions of law. Full stop. Nevertheless, learned counsel would further submit that to show the bona fides of the petitioner will deposit a sum of rupees 10 lakhs within a period of 2 weeks from today. Stop. Thereafter, the petitioner will also deposit a reasonable amount within a given time frame. Full stop. Next para. Consequently, there shall be an ad interim order of stay of all further proceedings pursuant to the impugned auction notice dated 16/5/2023 at Annexure D, till the next date of hearing, subject to the petitioner depositing a sum of rupees 10 lakhs with the first respondent cooperative society within a period of 2 weeks from today. Stop. Acknowledgement for having deposited the same shall be furnished in the office. Full stop. The petitioner, it is also required to pay another sum of rupees 10 lakhs within a period of 4 weeks on the expiry of the 2 weeks provided for the first installment. Stop. Failure on the part of the petitioner to comply with the directions issued by this court would render the petitioner ineligible for the interim relief granted herein. Full stop.
Page number 11.
ಎಲ್ಲಿಗೆ ತಗೊಂಡು ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು? I said Karnataka Advocates Welfare Fund. You have paid it to the Karnataka Bar Council. Huh? ಯಾವ್ದ್ರಿ ಇದು? This is a welfare fund. Cost receipt, Karnataka State Bar Council. ಹೌದು. $28,600. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕಟ್ಟಿರುತ್ತಾ? Although this court had directed costs of ₹2,000 payable to the Karnataka Advocates Welfare Fund, which is a period of 1 week from 21/6/2023. The learned counsel for petitioner has today furnished a receipt of having paid ₹2,000 to the welfare fund of the Karnataka State Bar Council. Stop. The payment of costs, though made to in the wrong welfare fund account, nevertheless, this court is satisfied with the costs paid. Yes. Wapas ಕೊಟ್ರು. Yes. How did you acquire the property? Huh? And what is the basis of your claim? Where is the registered sale deed? You have not filed objections? Yeah, no, 2012 matters, date given matters. What is this you are doing? Huh? That is why I am asking, what is the basis of your claim? I can't, that is not possible. With great difficulty, we reach final hearing matters and you go on asking for time. Not possible. Yes. What is the document that you submitted before the executive officer? What has he taken note of? Please read the order. Please read the order. Huh? 21. Yes. Huh?
ಇವರಿಗೆ ಸೇರಿತ್ತು ಸದರಿ ಕೊಟ್ಟದ್ದು ವಕೀಲುಗಾರ ನಾಯಿಯವರಾದ ಶ್ರೀಮತಿ ಸರ್ವಮ್ಮ ವಾಮದೇವಯ್ಯ ಇವರು ದಿನಾಂಕ 13/4/1973ರಂದು SR ನಂಬರ್ 4 ಹೊಂದಿಕೊಂಡು ಸ್ವಾಧೀನ ಮತ್ತು ಅನುಭವ ಪ್ರಯತ್ನದ ಆಧಾರದಿಂದ ಸದರಿ ಸ್ವತ್ತಿನ ಖಾತೆಯು ವಕೀಲರ ತಾಯಿಯವರ ಹೆಸರಿನಲ್ಲಿ
ಸರ್ವಮ್ಮ
ಇವರಿಗೆ ನಿವೇಶನ ನೋಂದಣಿ ಸರ್ವಮ್ಮ ಇವರ ಮರಣ
ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರಿಂದ ಶ್ರೀಮತಿ ಸರ್ವಮ್ಮ ಇದು ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್. ಅಂದ್ರೆ ಬಿಟ್ವೀನ್ the brothers they have executed a relinquishment deed in your favor. KM ಶಿವಯೋಗಿ ಯಾರು LS ಶಿವಯೋಗಿ ಅವರು ಇವರು KM ಶಿವಯೋಗಿ ಶ್ರೀಮತಿ ಸರೋಜಮ್ಮ ರವರ ಯಜಮಾನರಾದ KM ಶಿವಯೋಗಿ ಇವರಿಂದ ಹಕ್ಕು ಖುಲಾಸೆ ಪತ್ರ. ಪ್ರತಿವಾದ ಒಂದು ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಗಳ ವಿವರ ಓದಿ. So you don't have any document other than the assessment copy extracts. You have no other document. No. Let us see what are the consideration. Yes.
ಸರ್ವಮ್ಮ ವಾಸದ ದೇವಯ್ಯ ಅವರಿಗೆ ಕಾಲೇಜು ಸುಮಾರಿ ಸಂಖ್ಯೆ 649ರಲ್ಲಿ 31/19 ಖಾಲಿ ನಿವೇಶನ ಪಡೆದಿದ್ದು ದಿನಾಂಕ 20/11/2019 ಮಲ್ಲಿಕಾರ್ಜುನಯ್ಯ ರವರು ತಮ್ಮ ತಾಯಿಯವರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿಕೊಡಲು ಅರ್ಜಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಶಾಂತಿಯಲ್ಲಿರುವ 1997ರಿಂದ 2012-13ಗೆ ಅಸೆಸ್ಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ನಲ್ಲಿ ಕೃಷ್ಣಮೂರ್ತಿ ಅಯ್ಯಂಗಾರ್ ಅವರಿಗೆ ಖಾತೆ ಇರುವುದಿಲ್ಲ ಮತ್ತು ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳು ನೀಡುವ ಖಾತೆಯಂತೆ ಅಸೆಸ್ಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ನಲ್ಲಿ ಶ್ರೀ LS ಶಿವಯೋಗಿ ಸೋಮಶೇಖರಯ್ಯ ಅವರಿಗೆ ಹೆಸರಿಗೆ ಖಾತೆ ದಾಖಲಾಗಿರುತ್ತದೆ.
ಓದಿ ಹಂಗೆ ಓದಿ ತಿದ್ದುಪಡಿ ವಿವರ.
ಪಶ್ಚಿಮಕ್ಕೆ ಗೌರಿಬಾಯಿ, ಓಂ ನಾಗೇಶ್ವರ ರಾವ್, ಉತ್ತರಕ್ಕೆ ಕನ್ಸರ್ವೆನ್ಸಿ ಮತ್ತು ದಕ್ಷಿಣಕ್ಕೆ ಮಿಡ್ಲ್ ಸ್ಕೂಲ್ ರಸ್ತೆ ಎಂದಿರುತ್ತದೆ. ಆದರೆ ಹಾಲಿ ಅಸೆಸ್ಮೆಂಟ್ ನಲ್ಲಿ ವೈದ್ಯ ಪ್ರಕಾರ ಚೆಕ್ಕು ಬಂದಿದೆ. ಗೋವಿಂದ ಸ್ವಾಮಿ, ಪಶ್ಚಿಮಕ್ಕೆ LS ಹೋಗಿ, ಉತ್ತರಕ್ಕೆ ಕನ್ಸರ್ವೆನ್ಸಿ, ದಕ್ಷಿಣಕ್ಕೆ ಮಿಡ್ಲ್ ಸ್ಕೂಲ್ ರಸ್ತೆ ಎಂದು ಇದ್ದು ಬಂದಿದೆ. ವ್ಯತ್ಯಾಸ ಇರುತ್ತದೆ. ಸರ್ವಮ್ಮ, ಓ HM ವಾಸುದೇವಯ್ಯ ಇವರ ತಾಯಿಯವರು ಸುಮಾರು 690 ಅಡಿ ಉತ್ತರ, ದಕ್ಷಿಣಕ್ಕೆ 90 ಅಡಿ ನಿವೇಶನದ ಬಗ್ಗೆ KS ಕೃಷ್ಣಮೂರ್ತಿ ಅಯ್ಯಗಾರರಿಂದ ಖರೀದಿ ಮಾಡಿದ್ದು. ಸದರಿ ಖರೀದಿ ಪತ್ರ ತರೀಕೆರೆ ಉಪನಗರಾಭಿವೃದ್ಧಿ ಕಚೇರಿಯಲ್ಲಿ 13 ಆಗಿರುತ್ತದೆ. ಶಶಿಕಲಾ ಇವರ ತಾಯಿಯವರು 17/7/83ರಲ್ಲಿ ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ.
ಅಂದ್ರೆ 10 years after the sale deed was executed in favor of Shashikala, she passed away. She had not got the katha registered in her, transferred in her name. It is only her son who approaches the Gram Panchayat to transfer the katha. Hello. Shashikala ಅವರ ತಾಯಿ ಆಯ್ತು. Yes, Shashikala approaches. Yes. Annondu 2011 only. So from 1973 till 2011 you didn't get the katha transferred. And they have found that the previous katedar was that this person, LS Shivayogi. That sale deed was not executed by the petitioner. The sale deed was executed by some Iyengar, Krishnamurti Iyengar. Correct. It was in your name. Yes. So therefore, it's a dispute of title, which cannot be decided by the revenue authorities. You will have to go before the civil court. The revenue authorities cannot decide the question of title. If the previous katedar had executed the sale deed in your favor, then even if he raises an objection, it will not be upheld. Because he has executed a sale deed, the purchaser will have a right to get the katha transferred. But that is not which has happened here. Admittedly, the katha was standing in his name only. How could it be transferred? I mean, transferred now or changed in the year 2011, when admittedly the sale deed was executed somewhere in the year 1973. Perfect. So there may be a dispute regarding the identification of the property and consequently a dispute regarding the title. Today. That full bench decision. That is arising out of the Land Revenue Act. the petitioner is aggrieved of the impugned order dated the date 7/9/2012 at annexure K passed by the executive officer of the Taluk Panchayat. Tarikere. Stop. Next para. Learned counsel for the petitioner submits that the fourth respondent filed an appeal under section 269 of the Karnataka Gram Swaraj and Panchayat Raj Act before the executive officer seeking a direction to the Panchayat Development Officer of the Lakkavalli Gram Panchayat to enter her name Khatedar in respect of property bearing Khaneshumari number 649 situated at Durgi Gudi layout, Honnalli. No, she was residing there. This place is in Lakkavalli. Situated at the Lakkavalli village, measuring 30 feet into 90 feet. Stop. The claim to title at the hands of the fourth respondent was that her mother, Srimati Sarvamma, wife of H.M. Vamadevaya, had purchased the property in question under a registered sale deed dated 13th of April 1973. Stop. Srimati Sarvamma died on 18/7/1983. Stop. Thereafter, there was a family arrangement, and all the other members of the family executed relinquishment deeds in favor of the fourth respondent. Stop. Thereafter, the fourth respondent approached the executive officer of the Taluk Panchayat by filing an appeal and sought a direction to the Panchayat Development Officer to enter her name in the katha register. Stop. Next para. Notice was issued to the petitioner, and the petitioner appeared before the executive officer. Stop. Petitioner contended that the property has devolved on him through his ancestors, and he has been the khatedar of the property all along. Full stop. Learned Counsel submits that in the impugned order, the executive officer, in fact, found on verification of the records that the katha was standing in the name of the petitioner herein from the year 1996-97 to 2012-13. Stop. That being the position, it was impermissible for the executive officer to have allowed the appeal while directing transfer of katha in the name of the fourth respondent hearing. Stop. Yes. Yeah, file matter. Whoever has filed, let it be decided as and when the suit is decided and there is a declaration, you will be entitled to have your name entered in the katha register. It's as simple as that. Next para. For contra, learned counsel for the fourth respondent seeks to submit that by virtue of a registered instrument, the fourth respondent had a right to seek registration of katha in her name. Stop. Next para. Having heard the learned counsels and on perusing the petition papers, this court finds that firstly, there was no reason for the fourth respondent to have filed the appeal under section 269 of the Act. Stop. Section 269 of the Act empowers a person aggrieved of any original order passed by the Gram Panchayat to question the same, any original order or resolution passed by the Gram Panchayat to question the same before the executive officer within a period of 3 months. Within a period of 30 days from the date of such original order or resolution. Stop. Admittedly, no grounds are made out in the appeal which was filed before the executive officer to have invoked the said provision. Stop. There is no mention of the original order or resolution by which the fourth respondent was affected. Stop. On the other hand, the executive officer himself has found that the name of the petitioner existed in the katha register as the kathedar. Stop. No information is available to show when the name of the petitioner was originally entered in the katha register. Stop. No application is filed seeking condonation of delay by the fourth respondent before the executive officer. Stop. No orders have been passed condoning the delay. Stop. Moreover, if the executive officer found that disputed questions of title have been raised by the parties, the the executive officer should have directed the aggrieved person to approach a competent civil court to get a declaration of title. Stop. Next para. At this juncture, learned counsel for the fourth respondent submits that a suit is pending consideration before the civil court. Full stop. If that is so, comma, the parties can await the result of such suit. Full stop. It is also open for the fourth respondent to file a suit to get a declaration of title on the basis of the registered instrument. Full stop. As and when such declaration is made in favor of the fourth respondent will be entitled to have her name entered in the register of the Gram Panchayat. Full stop. Next para. For the reason stated above, comma, this court is of the considered opinion that the impugned order passed by the executive officer cannot be sustained. Full stop. Accordingly, the writ petition is allowed. Full stop. The impugned order dated 7/9/2012 at Annexure K passed by the executive officer of the Taluk Panchayat, Tarikere, is hereby quashed and set aside. Full stop. Ordered accordingly. ಹೌದು ಬಂದಿದೆ ಕರೆಕ್ಟ್ ಬಂದಿದೆ ಯಾವುದಕ್ಕೆ ಏನ್ ಮಾಡಕ್ No, see, if that benefit is available for you in terms of the provisions of the Limitation Act, you can make use of it. There cannot be a direction given by this court directing the civil court. Baradilla. In terms of the provisions of the Limitation Act, you are, if you are permitted to make use of this time spent here, you may accordingly seek condonation of delay. Baradilla, suit al baradilla. And there cannot be a direction given by the High Court. Adanna navu for filing of a suit, the High Courts cannot direct. Madak baradilla. ಹೆಂಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅದೇ ಆತರ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಹೈಕೋರ್ಟ್ ಕೆನಾಟ್ ಗಿವ್ ಸಚ್ ಡೈರೆಕ್ಷನ್ಸ್ ಎಸ್ ಇಟ್ ಇಸ್ ಇಫ್ ಇಟ್ ಇಸ್ ಅವೈಲಬಲ್ ಫಾರ್ ಯು ಇನ್ ಲಾ ಯು ಕ್ಯಾನ್ ಡೂ ಇಟ್ at the request of the learned counsel for the contesting respondent, release this matter on 5th of July. Twelfth of July. Huh? Huh? Date given matter ಈ ತರ ಬಂದು ಟೈಮ್ ಕೇಳ್ತಾರಲ್ಲ ಏನ್ ವಾಟ್ ಇಸ್ ದಿ ಮ್ಯಾಟರ್ ಅಬೌಟ್ ವಾಷಿಂಗ್ ಅನೆಕ್ಷರ್ ಹೆಚ್ ಏನ್ರಿ ಏನು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ 2018. Was there an order of stay? Stay ಆಗಿದೆಯಾ?
In view of the additional wage of attended for reinstatement. In that regard, Lord, I have given representation to the benefits. That is my statement of observation.
Which is the original order? Page number? That amount was recovered from the president and chief executive officer.
They are given undertaking. We get that repay the second.
Learned counsel for the second respondent submits that although the original order was passed on 17/10/2011, directing reinstatement of the second respondent to the services of the petitioner society, and the said order being upheld at the hands of the Karnataka Appellate Tribunal. Nevertheless, there was an interim order of stay granted by this court, and the second respondent was not reinstated. Stop. In the meanwhile, the second respondent has attained the age of superannuation on 31/5/2018. Stop. In that view of the matter, learned counsel for the second respondent submits that the petitioner society should be directed to consider settlement of the retirement benefits to the second respondent. Full stop. Next para. Learned counsel for the petitioner society is directed to take instructions in this regard and make his submissions on the next date of hearing. Full stop. Next para. Release this matter on 5th of July 2023. That is called out. There is no representation for either of the parties.
My lordship, I am for the respondent
56.
number 4 to 9, 16 and the, yes, my lordship. For
There is no representation for the petitioner. Stop. Release this matter on 5th of July.
yes, my lordship.
Does not survive. learned counsel for the petitioner submits that the prayer made in the writ petition does not survive for consideration due to effects of time. Stop. Consequently, learned counsel prays that the writ petition may accordingly be disposed of. Full stop. Next para. The submission of the learned counsel for petitioner is placed on record. Full stop. Accordingly, the writ petition stands disposed of as the prayer made in the writ petition do not survive for consideration.
Have my respondent, my lord, contesting respondent.
Yes.
Lord, this is with regard to the encashment of leave of an employee, retired employee, my lord, which has been denied. And dispute was raised before the ARCS, my lord, and ARCS upholds the decision of the management. Afterwards, my lord, the employee, the respondent, contesting respondent preferred an appeal before the KAT, my lord, and the KAT has allowed my claim, my lord, for the period of regarding the encashment of leave, against which the management has come before this court.
Right. Ultimately, he retired from service as state manager. But the type of salary was 85,000. Gratuity is was calculated at 22.5 months of salary, and the total amount paid was 8 lakh 90. 2 months leave encashment, that was also given. After taking that benefit, he quite saying that he declared just 15,831. And even encashment is declared to 10 months leave encashment. That was her stand. So actually, is that calculation of 35,752 2.5 months. It comes to 8 lakh more. But it was paid by two insurance LIC, but it was outsourced by society. LIC itself has paid that. 10 months he can get he is not integrated from that something the 11 14 he pays 1. They require the reality. They require reality. Back in the daily even the market, they transfer from more version of the other the compartment of the I can why change most of the either ವೇತನ ಪಡೆಯುವ ಸೌಲಭ್ಯ ಪ್ರತಿ ವರ್ಷದ ಜನವರಿ ತಿಂಗಳಿಂದ ಪ್ರಾರಂಭವಾಗಿ ಪ್ರತಿ 2 ತಿಂಗಳಿಗೆ ಹಾಗೆ ವರ್ಷ ವರ್ಧಿಸಿದ ರಜೆ 30 ದಿನಗಳಿಗೆ ಇರಬಹುದು. ಇದಕ್ಕೆ 2 ವರ್ಷಗಳ ಅವಧಿಗೆ 1/1/2012 Therefore, what it says is maximum she is entitled to get is only 2 months. More than that, she is not entitled.
So this provision has been considered.
Yes, considered. Section 70 dispute was dismissed. 11 portion was 70. Last one. What you on the next part?
Yes.
What you on the next one? What you come up? More complicated. ಈ ಬಗ್ಗೆ ಮೊದಲನೇ ಇವಾಗ ಸಿಬ್ಬಂದಿ ಸೇವಾ ನಿಯಮ ಈಶಾನ್ಯ ಆರ್ ಇವಾಗ ಆಡಳಿತ ಮಂಡಳಿ ನೌಕರರಿಗೆ ನಿವೃತ್ತಿಯ ನಂತರ ನೌಕರರ ಸೇವಾ ನಿಯಮಾವಳಿ ಕನ್ನಡ ಉಪವಿಧಿಯ ಭಾಗವಾಗಿರುತ್ತದೆ. ಈ ಹಿಂದೆ ದೂರದ ಉಪವಿಧಿಯಲ್ಲಿ ನಿಯಮಗಳ ವೈದ್ಯರಿಂದ ವೃತ್ತಿಪಡಿಸುವ ಸೌಲಭ್ಯವನ್ನು ಗಮನಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಯಾವ ವೃತ್ತಿಯಲ್ಲಿದೆ ಆ ನಿವೃತ್ತಿಗಿರುವಾಗ ಸೇವಾವಧಿ ವೈದ್ಯ ದಾಖಲಾಗಿದೆ.
Yes, what has the tribunal said? Now the only question is regarding leave encashment. Yes, other ಬಗ್ಗೆ ಹೇಳಿ ಸರ್.
ಇದು ಪ್ರಸ್ತಾವನೆಲ್ಲ ಗ್ರಾಚ್ಯುಟಿ ಬಗ್ಗೆ ಬರುತ್ತೆ.
Yes.
39 ವರ್ಷಗಳ ದೀರ್ಘಕಾಲ ಸೇವೆ ಸಲ್ಲಿಸಿ ನಿವೃತ್ತರಾದ ನೌಕರರಿಗೆ ರಜೆ ದೃಢೀಕರಣ ನಿಯಮಬದ್ಧವಾಗಿರುತ್ತದೆ. ಸಂಘದ ಉಪನಿಯಮ ರಜೆ ದೃಢೀಕರಣ ಏಕೆಂದರೆ ಯಾವುದೇ ಉಪನಿಯಮ ಅವಕಾಶ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಿರ್ದೇಶಿತವಾಗಿದ್ದರೆ ಅದು ನೋಂದಣಿ ಆದ್ದರಿಂದ ರಜೆ ದೃಢೀಕರಣ ಇದು ದಿನಾಂಕ 14 ಕರ್ನಾಟಕ ಸರ್ಕಾರ ನಿಯಮ 18ಕ್ಕೆ ವ್ಯತಿರಿಕ್ತವಾಗಿರುತ್ತದೆ. ಸಂಘವು ಈ ಮೇಲಿನ
What is this rule 18 or section 18?
Rule 18.
Rule 18 ಅಲ್ಲಿ ಯಾವುದು? Mr. Ballal.
Please, madam.
Rule 18 ಅಲ್ಲಿ ಯಾವುದು?
Rule 18, conditions of service of the employees of the cooperative societies.
ಅದರಲ್ಲಿ ಯಾವುದು?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಒಂದೇ ಸೆಕ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ. Every cooperative society shall lay down in its bylaw conditions of service of its employees. If it is not already laid down, it can be uncooperated within 3 months from the date of commencement of these rules. My lord, the relevant section would be, my lord, 11A of the Karnataka Societies Act, where it 11? Says that 11A, my lord, bylaws. Rule only says that, my lord, that it should be as per the bylaw of the individual societies, cooperative societies.
Yes.
11A of the Act, section 11A, my lord, refers to the bylaws. Every cooperative society shall make its bylaws in accordance with the provisions of this Act and the rules made thereunder.
Correct, sir. They have made it.
Yes, my lord. My lord, my submission to my lords is that, my lord, yes, there is a rule, no doubt, my lord, but the employees who have subsequently, I mean, after this bylaw was accepted by the cooperative societies registrar and approved, there are 3 persons who have retired prior to me, my lord, in the year 2012, 13 and 14. All of them have given the benefit of 10 months encashment of leave. Only
what documents did you produce?
No, my lord, I have only the references, my lord. These references were given, shared with Mr. Uppin also, my lord. He said on the last occasion that he will verify from his management, my lord. There are 3 persons: general manager by Shekhar Acharya, Raghu Pujari, and Isaac David. Let them file an affidavit saying that, my lord, they have not given that benefit to them, my lord.
On the plain reading of the provisions that you read out, it doesn't say that it has to be restricted for a period of 2 months.
And my lord, their reason given by them is that, my lord, the society is under loss, my lord, which is factually incorrect.
Huh? For a year. Yes, for a year.
Next class says that ಅಪಾರ್ಥ ರಜೆ ಈ ವರ್ಷದ ಆಯಾ ವರ್ಷಕ್ಕೆ ಜನವರಿ ತಿಂಗಳಿಂದ ಪ್ರಾರಂಭವಾಗಿ ಪ್ರತಿ 2 ವರ್ಷಗಳಿಗೆ ಹಾಗೆ ವರ್ಷ ಒಂದು ರಜೆಯ ಮತ್ತು 30 ದಿನಗಳಿಗೆ ಇರಬಾರದು.
Correct. ವರ್ಷ it should not exceed 30 days. It is repeating what is said in the first clause, and the period has to be counted from January to December. There is restriction that during the attainment of age of superannuation, there is no provision for seeking encashment of leave for all the years. ಇಲ್ಲ ಆ ತರದೇನು ಪ್ರಾವಿಷನ್ ಇಲ್ಲ. That is for the year, sir. ನಿಮ್ಗೆ ಇವಾಗ 2 months ಅಂತ ಎಲ್ಲಿಂದ ಸಿಕ್ತು? 2 months ಅಂತ ಎಲ್ಲಿಂದ ಸಿಕ್ತು?
2 ವರ್ಷಗಳ ಅವಧಿ.
Correct. 2 years. ಆಯ್ತು. From where did you get this provision that it cannot exceed 2 months? ಅವ್ರೇನು ಹೇಳಿಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ.
Lord, my submission to my lord is that, my lord, your lordship has correctly interpreted, my lord. It doesn't restrict for only 2 months.
ಅಲ್ಲ, regarding gratuity.
Gratuity, my lord, what has been paid is, I accept that, my lord, because gratuity, because it has been settled by the LIC corporation itself.
Yes.
I cannot.
The petitioner society is aggrieved of the impugned order dated 6th of July 2018, passed by the Karnataka Appellate Tribunal, Bengaluru, in appeal number 117 of 2017. Stop. Next paragraph. The petitioner, who had the third respondent, who had served in the petitioner society in various capacities, ultimately attained the age of superannuation on 31/5/2014. So, when the retirement benefits of the third respondent was paid, the third respondent raised a dispute before the second respondent, Assistant Registrar of Cooperative Societies, Kundapura Subdivision. Seeking, making a claim that the petitioner society is due to pay balance amount of rupees 17,831 towards gratuity and rupees 3,57,750 towards the leave encash. Stop. The Assistant Registrar of Cooperative Societies by order dated 14/3/2017, allowed the dispute.
Dismiss the dispute.
Dismissed the dispute. Full stop. The third respondent approached the tribunal by filing an appeal.
Page 19, my lord, order.
Full stop. The tribunal although noticed the admission of the third respondent in respect of receipt of rupees 4 lakhs,
8 lakhs, 8 lakhs for.
Now the words 8 lakhs
4,419, my lord.
8 lakhs 4,419
Yes.
towards
Gratuity.
paid through Life Insurance Corporation of India, nevertheless held that the petitioner was entitled for payment of interest at the rate of 8% per annum on every month's delay in payment of the gratuity. Stop. Insofar as the claim of the third respondent regarding leave encashment, the tribunal held that in terms of Rule 18 of the Karnataka Cooperative Societies Rules, 1960, the reasons furnished by the petitioner society to restrict the payment of leave encashment only for a period of 2 months was found to be contrary to the provisions. Stop. Therefore, the appeal filed by the third respondent was allowed, and a direction was given by the tribunal regarding payment of interest towards the gratuity and the leave encashment as claimed by the petitioner, but the third respondent. Full stop. Next para. Learned counsel for the petitioner society submits that insofar as the payment of gratuity is concerned, the third respondent is satisfied with the payment. However, her dispute continues in respect of the payment of earned leave. Stop. Learned counsel has drawn the attention of this court to the bylaws of the society, and there are specific provisions contained in the bylaws regarding leave encashment. Stop. Learned counsel submits that the leave encashment for a period of 2 months has been given to the third respondent accordingly, and no fault could be found with the petitioner society. Stop. Next para. Having considered the bylaws of the society, and more particularly the leave encashment, provisions regarding leave encashment, this court finds that there is no such restriction that could be found from the provisions of the bylaws restricting leave encashment only for a period of 2 months at the time of the retirement of an employee of the society. We'll stop. Clause 1 of the provisions regarding leave encashment provides that a maximum of 30 days leave encashment shall be provided. Stop. In clause 2, the period for computation of leave encashment is specified, stating that it shall commence from 1st of the year and end on the 1st of January every year and end on 31st of December. Stop. The period is to be calculated for 2 years. Stop. Other than such a provision, this court does not find any restriction that at the time of retirement, even if the employee is entitled for a maximum of 30 days leave encashment for every year, the same is to be restricted for a period of 2 months. Stop. This contention at the hands of the petitioner society accepted. Stop. The tribunal has rightly found fault with the orders passed by the Assistant Registrar of Cooperative Societies. Stop. Next para. Learned counsel for the petitioner, for the third respondent, has fairly submitted that the third respondent does not claim any further in respect of the gratuity. Stop. However, in respect of the leave encashment, necessary orders may be passed. Stop. Next para. Consequently, the writ petition is partly allowed. Stop. Directions are hereby issued to the petitioner society to settle the leave encashment as claimed by the petitioner, as expeditiously as possible. Third respondent
Issue to the petitioner society to settle.
As claimed by the third respondent. As expeditiously as possible and at any rate within a period of 3 months from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
Lord, some interest also, my lord, because they have holding my money for such a long period, my lord, from 2014 till 2023, my lord. Some reasonable interest. 8% was granted by the tribunal.
The petitioner society shall settle the leave encashment to the third respondent along with interest calculated at the rate of 6% per annum. Yes.
Obligement.
I read a wrong submission over. Actually, I went only where the question
ನಿಮ್ದು ಯಾವ್ದು? ನಿಮ್ದು ಯಾವ್ದು? 61. That same order will be in serial number 61. Huh? ಯಾವ್ದು? 7 release this matter on 5th of July. Next Wednesday. Yes. All other matters next week. ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಇವಾಗ? Order wherever actually have to be extended, you please mention it to be extended. Date ಯಾವ್ದಕ್ಕೂ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. It will come up next week.
Court officer. Court officer. Sir. Sir, ಕೇಳಿಸ್ತಿದೆಯಾ? Court officer. Court officer. Court officer.
ಟ್ಯಾಕ್ಸ್ ಏನು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಚಳಿ ಇದಾಗುತ್ತೆ ಅವೆಲ್ಲ ಇಲ್ಲ ಇದೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆ ರೆಕಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ರೆಕಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ